Therefore, one trying to find dates up, my lord, so many dates are there, allowing to supplement to epithet it with
Review petition. Which is the order?
I'm issuing the order of the divisional bench that the order dated 26/9/2019, passed in WA 399 of 2019.
So let us see what is the merit. Unnecessarily review application
lord.
should not remain pending.
My
This has remained pending for more than 5 years.
lord. Here, my lord, the petitioner was appointed as electrical overseer in the year, my lord, 1967, my lord.
Where is the order?
That is in the writ petition, my lord.
You have not filed copy in the review application.
I have filed the order of the division bench in the honorable division bench in the review application, my lord. Where the cases have come attacked allowing this, my lord. The writ petition allowing the writ of appeal, my lord. My lord, for my lord convenience, I say,
Is this the order impugned 26/9/2019?
my lord,
Page 12.
my lord. I am placing that order, my lord.
Next.
Now place the order, my lord.
So how can you seek review of an order passed in appeal?
In view of the fact
On what
that
ground?
there is errors apparent on the face of that formula.
Where is that?
The writ petition as well as the writ appeal were dismissed solely based on the ground of limitation, my lord. In fact, there is no limitation. If your lordship should kindly peruse Annexure 7 of the writ petition, my lord. In fact, there was no delay on the part of the petitioner, my lord. What has happened, my lord? In 67, the petitioner was appointed as electrical overseer, my lord. Thereafter, my lord, in 1986, my lord, he was promoted to the post of assistant engineer on ad hoc basis. As per government notification, my lord. As per government notification, I have filed, my lord.
Come to paragraph 5 of the order.
My lord. The petitioner has already retired from service since 2002 and has also received all financial retirement. He has approached this court in the aforesaid writ petition. On the finding as discussed herein above, the learned single judge has dismissed the writ petition by the interim order. What has happened, my lord? Reversal order was passed in 2001, my lord. He was promoted to the post of assistant engineer in the year 1986 after 14 years, my lord, without any rules by the OSED, as has been directed in another writ petition, my lord.
You could have approached the court soon after your retirement.
In view of the fact that he could not know the result of his representation, my lord. The representation was filed soon after this reversal order, my lord, and it was kept pending for 6 years, my lord. 4 years. It was kept for pending for 4 years, my lord.
Petitioner in the present writ application seeking review of an order dated 26/9/2019, passed in WA number 399 of 2019. Stop. Next. Sealing an order dated 5/8/2019, passed by a learned single judge of this court in WPC number 12722 of 2009. The said intra-court appeal was filed. Stop. The petitioner's writ application was dismissed mainly on the ground of delay, in as much as after his retirement in 2002 from the post of assistant engineer,
assistant engineer.
from the post of assistant engineer bracketed electrical on ad hoc basis, comma, he approached this court in 2008, raising grievances relating to his entitlements during the service period. First off, learned single judge, learned single, the division bench by the order under review refused to interfere with the order of the learned single judge, taking into account the law laid down by the Supreme Court in case of Tarsem Singh. Union of India versus Tarsem Singh, reported in 2008, volume 8, SCC 648. Next. Learned counsel appearing on behalf of the petitioner has argued that there is error apparent on record in the impugned order, and therefore this court should review the said order. So Safi has submitted that the petitioner did not have any knowledge about the subsequent development after his retirement relating to grant of promotion,
Pensionary benefit. Yeah.
relating to grant of pensionary benefits. Stop. Next. We do not find any substance in this said submission made on behalf of the petitioner for the reason that he approached the court 6 years after his retirement, raising his service-related claim. Stop. We do not find it to be a fit case for exercise of our review jurisdiction, comma, in the facts and circumstances. Stop. This application is accordingly dismissed. Yes.
Item number 2.
During this one D. It is that for B, authentication fee is not paid, my lord. I am filing today, my lord. And the challenging the order passed by the Honorable Single Judge under Annexure 4, my lord. On the ground that the petition has submitted the false mark sheet at the time of selection, which is not correct, my lord. We will get no false certificate as published by the authority with regard to the mark sheet. And it has been held by the Utkal University that the marks issued by
Where is
the
the order? Where is the order?
Annexure 4 starts from page 80.
Yes.
Starts from 81, my lord. Petition only appointed as a assistant Shiksha Sahayaka, thereafter recognized as a assistant teacher, 2006, and continued for 2 years, 16, and his service has been terminated, my lord. On the ground that he has produced the birth certificate, Shiksha Sahayaka. Thereafter, Shiksha Sahayaka.
Shiksha Sahayaka.
Sahayaka. Thereafter, his service was regularized as assistant teacher, a private school. Outside of made an application before the authority that he has submitted birth certificate. That has been entered in. And after 13 years, he was terminated.
You could not have been selected. So that
They have given the appointment on the basis of that certificate and
fraudulently, you also.
So that is not fraud. Absolutely, that is not fraud. You will also be tired of this birth certificate, then equipment center is a fraud.
You also understand. You must have taken instructions from your client. He must have disclosed everything to you.
Kindness of the collector, chairman of the service, you must have submitted the first certificate. Must have submitted the land is as such. In proportional case, reported.
All right, you have understood. The appellant has put to challenge and a judgment of learned single judge of this court dated 2/8/2023 passed in WP, delivered in WPC number, WPC bracketed OA number 2665 of 2016, whereby the appellant's writ application came to be dismissed. So the short facts for consideration are that pursuant to an advertisement issued in 2003 for selection and engagement of Shiksha Sahayak, the appellant had applied and he or she, and on being found suitable, he was engaged by an order dated 16/12/2003. Stop. In the light of an order of this court passed on 28, passed in WPC number 11748 of 2003, the petitioner was disengaged so, however, he or she, however, the petitioner was subsequently re-engaged on 28/9/2005. Huh? 2005. Stop. In the year 2010, a so-called notice was issued to him with the allegation that he had submitted forged and fabricated certificates and mark sheets in support of his educational qualifications. First off, he was asked to submit the mark sheets and certificates in support of his educational qualification. Stop. The page. No. The petitioner, the appellant, is said to have you submitted your originals.
Yes, sir.
Said to have submitted.
Starting from page 67 to 70.
Just a minute. it further transpires that an allegation was made by a private person to the effect that by producing fake BA and B.Ed certificates along with fake mark sheets, the appellant had managed to get engagement as Shiksha Sahayak in the year 2005. So stop. Based on said allegation, another so-called notice was issued to the appellant asking him to show cause as regards submission of fake BA and B.Ed certificates for his selection as Shiksha Sahayak. So stop. Learned counsel for the appellant has vehemently argued assailing the impugned order passed by the learned single judge the appellant's service was terminated on the ground that the ground finding variance in evaluation of his merit based on merit at the time of selection for engagement at Shiksha Sahayak and the documents produced by him pursuant to the so-called notice issued to him. Stop. His appointment as Shiksha Sahayak, engagement as Shiksha Sahayak, and subsequent appointment as teacher. What is that post?
Regular teacher, assistant teacher.
As regular teacher came to be
Service was regular 2010. Service was regularized as assistant teacher in the year 2010.
his Sahayak and his appointment and his subsequent appointment as school teacher came to be terminated by an order dated 28/10/2016 passed by the collector cum chairman SSA Bhadrak. What is SSA?
Right.
What is SSA?
Sarva Shiksha Abhiyan.
Sarva Shiksha Abhiyan. Sarva Shiksha Abhiyan. Bhadrak. Passed in miscellaneous case number 1 of 2016, which was subject matter of challenge in WPC bracketed OA number 2665 of 2016. Stop. Learned counsel appearing on behalf of the appellant assailing the impugned order passed by the learned single judge has submitted that the respondents could not produce at any stage any forged document submitted by the appellant. First off, he, however, does not dispute the factual aspect that the marks evaluated at the time of selection by the selection committee was not in conformity with the mark sheets and the certificates which the appellant was actually possessing. First off, he submits that it may be a case of wrong evaluation of the appellant's score for the purpose of his selection as Shiksha Sahayak, but it cannot be said that the appellant had submitted forged and fabricated documents at the time of making application for the purpose of selection. First off, he accordingly contains that his engagement as Shiksha Sahayak and appointment as regular teacher was wrongly terminated by the collector and the learned single judge without appreciating the crucial aspects. The crucial aspect that the appellant had not submitted any forged certificate, dismissed the writ petition. So stop. 95.3.
93. Last one.
Stop. And next, learned single judge has taken into account meticulously the circumstance in which the appellant was selected. Based on the score said to have been calculated on the basis of the documents submitted by him at the time of selection. So stop. Next. In such view of it being an admitted position that the appellant's initial engagement learned counsel for the appellant agrees that had the actual marks scored by the appellant based on certificates produced by certificates available with him were rightly assessed, he would not have been selected for engagement as Shiksha Sahayak. Stop. Such being the position, we are not inclined to interfere with. Such being the position, we do not find any legal infirmity in the impugned judgment of the learned single judge. The single judge requiring interference in an intra-court appeal. Stop. This appeal has no merit and is accordingly dismissed. Yes.
Item number 3.
May I please Lordship? Appellant's read petition was rejected on 3 grounds. The annex here challenged the read petition under Annex 6, which his candidature has been rejected because it doesn't have the requisite training qualification. Which and the second was the honorable single judge doesn't want to interfere with the recruitment of 2014 and 15, and the third point was there was no stay. Here, Your Lordship, initially the petitioner approached for the post of contract Hindi teacher, but his application was rejected thrice. First for the overhead, secondly
This relates to what?
Ultimately it was rejected because I don't possess the requisite training qualification. But said that, Your Lordship, since 1995, I have qualified the Hindi teacher training qualification, which I have also annexed. Your Lordship, at page 38, Hindi teacher, I have qualified Hindi teacher certificate exam, that is equivalent to the training qualification where it has been reflected. I will,
So where is the advertisement?
Your Lordship, advertisement is at annexure 4,
Annexure 4.
Your Lordship.
Yes,
Sorry, it's
annexure 4.
it's annexus 3, Your Lordship.
Three.
Sorry for the
All right,
mistake.
all right. Yes. So what was the qualification prescribed?
Here, the relevant base is starting from 45, the Hindi teacher qualification, bachelor's degree from a recognized university with Hindi as one of the elective subject with minimum.
Just a minute, where are you reading?
Your Lordship, page 45,
Page 45, yes.
point F, Hindi teacher's qualification.
Arts teacher, science teacher, classical
Classical teacher Sanskrit,
No, after that, Hindi
classical
teacher.
Urdu, classical Telugu, Hindi teacher. Yes.
Teacher. Bachelor's degree from a recognized university with Hindi as one of the elective subject with minimum 50% mark in aggregate. So and so, or with Rashtravacha Ratna from Rashtravacha Prachar Samiti, Wardha, or with Sastri from
So
Odisha.
you fall in which category?
I fall in the second here, Your Lordship. That is,
Ratna.
no, they says that I don't have the B.Ed qualification. The training qualification is equivalent to B.Ed. They says that I don't possess the B.Ed qualification, but it is wrong, Your Lordship. I have already, I do have qualified the B.Ed exam since 1995. And my B.Ed is my Hindi teachers training certificate is equivalent to B.Ed.
There is no question of equivalent. The question of equivalence will arise only if it is there in the advertisement.
Your Lordship,
If the advertisement says that this qualification or any other equivalent qualification, then the question of equivalence arise.
I am coming
There is
to
no such stipulation, that will not arise.
I am coming to it, Your Lordship. Your Lordship may kindly see page 54.
No, this is the advertisement.
Your Lordship.
So whether you qualify or not.
Here they say that
Is it your case that as per the qualification prescribed in the resolution, you have the qualification?
Your Lordship.
Where is that?
See, Your Lordship, here what happened, I possess Hindi teacher training certificate qualification, which is equivalent to training, and here this is equivalent to Hindi.
This is not training, madam. This is bachelor's degree from recognized.
That we have, that they admit. But the second thing is B.Ed. At
Where?
page 46, the next page, Your Lordship, 46 says about B.Ed exam.
Where?
Page
First
46,
qualification you have.
Your Lordship.
This bachelor degree from recognized university you have.
Yes,
You are BA.
Your Lordship.
Then
Thereafter, they dispute that I don't have the B.Ed qualification.
and
Where is the problem?
and you have this also and section.
Your Lordship, here the relevant portion is Hindi Sikya Paragat from Kendriya Hindi Snatak Agra or BHED, a course prescribed by NCTE from an institute recognized by NCTET and affiliated to the recognized university B.Ed in Hindi. I do have B.Ed in Hindi, Your Lordship. How I will prove it, Your Lordship? I will show the relevant page with Your Lordship's permission.
Yes.
Your Lordship. Thereafter, I draw Your Lordship's attention to page 54, Your Lordship.
Yes, 54.
54. Page 54, para 8. May I permit to place the same, Your Lordship?
Yes.
Page 54, para 8. With regard to the equivalency of Hindi teacher training certificate course with that of B.Ed degree, the principal Hindi Training Institute, Cuttack, has clarified that the course's syllabus at the status of Hindi teacher training certificate course have been increased to a higher level, which is equivalent to that or Hindi Sikhya Pranagat, which is reflected in the notification, Your Lordship. Course conducted by the Central Institute of Hindi, Agra. He has further clarified that the duration of 3 examinations, that is Hindi teacher training certificate, Hindi Sikhya Pranagat and B.Ed are same. That is 1 year duration. Their courses are equal in content and recommended for declaring Hindi teacher training certificate course as equivalent to B.Ed degree and to allow higher scale of pay. Wide letter so and so. The Director Secondary Education Odisha has offered the same view to allow the status of scale of pay to Hindi teacher with that.
Madam, again, we are putting the same question. Whether you possess the qualification as prescribed in the advertisement or not, without equivalent. Because the question of the fact whether you possess equivalent qualification will arise only if in the advertisement it is mentioned that equivalent qualification is also valid qualification. Are we clear?
Your Lordship.
So suppose the advertisement, this just by way of illustration, the advertisement says that BA in Hindi from Utkal University will be a valid qualification. You say that BA from some other university is also equivalent to BA, and therefore I am entitled. So the advertisement may be bad. You did not challenge that. Now you cannot say that you do have the equivalent qualification, therefore you are qualified.
Your Lordship, in B, this says that you must be qualified in Hindi, you must be having BA in Hindi. Your Lordship, for that, the checklist which has been issued by the authority, while Your Lordship, I kindly see page 63, Your Lordship.
What is the reasoning given by? Yes, 63.
Yes, Your Lordship. At serial 4.
Yes.
Against BED, they have given my qualification as HTPC.
No, you are reading what? Page 63.
Page 63, Your Lordship.
Yes, checklist.
Your Lordship.
Yes.
Because I do possess the B.Ed qualification, so they have endorsed my qualification as B.Ed in this checklist.
Maybe incorrect. We don't know. The question.
Then second, they have marked the same, Your Lordship.
Maybe, madam. The basic question is whether you have the qualification as per the advertisement or not.
I am B.Ed in Hindi, Your Lordship, as per the advertisement.
BA in Hindi as per the advertisement.
Your Lordship. B.Ed in Hindi.
Yes. Whether this matter has been decided, considered
Yes,
in one of the cases.
My lord has heard, my lords have heard one matter,
Yes.
similar matter, where Mr. Samir Das was arguing, and I was also arguing this side. And this matter, my lord, since I was arguing before the honorable single judge, so I know it, man. Here, this matter, the question was the petitioner acquired his BA in 2013. Now, how could he acquire BA, a subsequent qualification in 95? That is not there in the, my lord. The question is BA, my lord knows. BA comes after BA. So his BA qualification is also a equivalent qualification. He is not normal BA. He is holding a qualification equal to BA. Snatak. It's not normal graduation.
But under that resolution, it says Ratna or Shastri, that is.
But that he acquires in 2013. Now, this, which he says equivalent not provided. My lord's first question, probably my my young friend has not understood. She possesses a qualification equivalent, not the qualification advertised. That question, the answer given by her that yes, it's wrong. She possesses a equivalent qualification. It's not the advertised qualification, my lord, first of all. Second, which I tried to bring it to my lord's notice, a graduation, B.Ed comes after BA, my lord. Now, she acquires BA equivalency in 2013, but has acquired the B.Ed in 95. So, that was the ground for which Honorable Single Judge didn't interfere.
Your Lordship may kindly see page 37. That is my BA qualification Snaptak, which I qualified since 1990. Thereafter, I qualified B.Ed. The next page 38, 1995. Snaptak I qualified since 1990.
If 38 is not there, it has not been scanned. Page 38 has not been scanned. It is not there in the brief.
I will file that, Your Lordship. It might have missed. I have while filing.
It's not at all.
Yes, it's there, Your Lordship.
Not at all.
Very good. As requested on behalf of the applicant, list this matter on 1B so as to enable her bring on record visible copies of the pages. Pages, which page?
That is page 38,
And
37 and 38.
yes, 37 and 38. And what is this Hindi Shiksha Samiti? Hindi Shiksha Samiti is a government.
Your Lordship, it's a government institute.
My lord, it is declared equivalent. But it's not in the advertisement. That is the question.
No, but see, this is equivalent.
My lord.
But this was a requisite qualification for admission to B.Ed.
My lord.
All right. So therefore, he acquired BA qualification based on this. But he did not have that BA. Therefore, after having had B.Ed qualification, whether it was, he obtained BA degree also. So a BA degree subsequent to BA, is it impermissible? Was it impermissible for the appellant to have acquired BA degree second time? BA in Hindi and again BA something.
May not be, ma'am. May not. No, may not be impermissible.
May not be impermissible. So the first qualification that he had BA, that is there.
My lord.
And then subsequent qualification of BA, that is also there.
But my lord, the B.Ed certificate she possesses now is not there in the advertisement.
B.Ed,
B.Ed, the training, what she is claiming now? She is now claiming the B.Ed. I have a training qualification. Yes, she says it's equivalent, but equivalence is not provided in the advertisement.
Equivalent training is there, which is not there.
So what is training?
Training, the advertisement specifies from only 2 institutes. My lords have already heard it on that day. My lord, I will take my lord again there. Case 44. 45 is the relevant case now.
Come to 46. First part is there.
My lord.
Second part
And
is,
my lord may come to
Hindi-
and.
and Hindi Shiksha
Shikshan Aurangzeb from Kendriya Hindi Sansthan Agra
oblique BSED
by from Institute NCT affiliated recognized university / B.Ed in Hindi, a course presented from Dakshina Bharata Hindi Prachar Sabha Madras Institute. So my lord, the advertisement goes one step further, specifying the institute. That was not under challenge.
then there, and at the end it is written affiliated to a
Yes,
recognized university
yes, ma'am.
or bachelor degree with Hindi. That is one of the
The other day, my lord, sir also asking me the same question because how it is specified from 2 institutes.
So what happened in that case?
Order reserved.
Order, not.
So, but that is the advertisement, ma'am. And on that basis, the entire recruitment has been carried out.
So we'll see, let the judgment come in that case.
As your lordship pleases. There are 57 posts are lying vacant, which I have obtained through RTI.
No.
I pray till that
Which is that case?
I will give the number.
your lordship 57 posts are lying vacant.
Let us see, your documents are not legible. What can be done?
But just see 46, just see that there is a condition. Untrained candidates shall have to undergo the required training within the time frame government prescribed by the government.
My lord, that
That means the untrained teacher also you appoint, it give them an option
my lord,
for getting it trained.
that relates to category 2, ma'am. My lord will see. There are 2 categories, or, and there is
It requires a time going to deliberation.
a category 2 qualification.
Okay, anyway, judgment is reserved.
Well, that was heard extensively.
How many years you have been working?
No, she was
No,
not
not
selected.
appointed.
She was
Okay.
rejected. Her candidature was rejected.
My only point before your
We
lordship.
have understood.
Your lordship.
Please do that. Please file those documents,
As your lordship.
2 weeks.
Item number 4.
May I pray, your lordship? Krishna challenge the honorable single choice order, my lord. At the last page. Annex 10, page 29, lord. And honorable, because that application has been filed to recall his lordship's order dated 29/22, passed on Annex 7, page 24. That order will pass on the misconception that the application has been infructuous. But the similar matters have been disposed of later on by the Honorable Court, my lord, because it happens, my lord, the advocate appearing for the petition, original petitioner, Mr. Patnaik, has died in the meantime. So when the matter was taken up before Honorable Single Judge, in his absence, the order was passed that the matter has been infructuous. For that reason, I have filed an application to recall that
His
order.
appearance is there, Mr. S. Patnaik.
Yes, Patnaik. He has died by the time the matter was listed before the Honorable Single Judge.
So on the date, on 28/9/2022, Mr. Patnaik was no more.
Not there, my lord. Before that, when I had stroke, he has expired.
Yes. Yes. If you notice. Mr. So accepts notice on behalf of. Response number? Response number?
I am for the statement.
State.
All the respondents. All the rest. Only respondent 1 and 2 staff select, Odisha staff selection comes and they have to.
Staff selection, you don't appear.
Normal.
Then 1 and 2 you appear.
I am appeal for 1 and 2.
I'll take notice to against open number 3.
OP3.
Notice. OP3 notice will go. Who is OP3?
Who is it?
Staff selection commission, my lord.
Staff.
They have counsel there.
Specific councils, I can intimate them. You'll also call this matter on Monday. I'll intimate who is appearing Odisha staff selection commission. Let a copy of the memo of appeal is served upon. Normally, they are the
Who is
recruiting.
contesting? You are contesting part.
No, in fact, they are the recruiting agency. Enter grievance is against that recruiting body. Passed only on the ground that it can be remanded. 2 copies of the memo of appeal be served upon learned counsel who represents the staff selection commission by Monday. Stop. This is appeal on. Next Friday. Have you, Mr. Counsel, have you enclosed death certificate?
No, I have not yet enclosed.
You should have done that. This is the ground taken by you that learned counsel who was conducting the case was no more on the date when the order was passed. So that was the most valid thing.
Death certificate I cannot obtain, my lord, because
You
only.
cannot, have you stated?
I have stated, sir.
You have stated.
I have stated, specifically. On that affidavit, I have stated, sir.
Item number 5.
Item 5 at next week, Monday, as because the conducting council illness and one for the medical checkup. Mr. Patnaik.
Learned counsel, Mr. Satyabrat Dheer.
Sir Patnaik.
Learned counsel for the petitioner states that learned counsel who has to argue the matter is indisposed. Stop. As requested, list this matter on 2 weeks.
Item number 6.
May I please, Lord, sir? The appellant was initially appointed as Shiksha Sahayaka and on completion of satisfactory service of 6 years, his services was regularized against the post of legal 5A teacher in primary school. My regulation order is annexation 1 page 20 on 26/3/2010. After regulation, the appellant was appointed as CRCC, that is Cluster Resource Center Coordinators. The duty of CRCs is to monitor teaching in high schools. Teaching in schools, madam.
Culture.
Center, Cluster Resource Center Coordinators. Cluster Resource Center Coordinators, that is CRCC.
Then
Your Lordship, can see CRCC appointment letter. That is page 25 at annex 4, madam. This is important, I may kindly candidate to place, my lord.
No, this is joining letter or appointment?
Appointment letter.
Yes.
In pursuant to letter number so-and-so of State Project Director OPEPA, Bhubaneswar, read with approval of the merit list of hygienic test of engagement of CRCC by Collector cum Chairman SSS, Cuttack, the following teachers are hereby selected.
So what do you want?
My appointing authority, so far as CRCC is concerned,
So this appointment was only for 5 years.
5 years. What I humbly salute, while continuing as CRCC, my appointing authority is the committee headed by the collector, and appointment order was issued by the district project coordinator. While continuing as CRCC, proceeding was initiated by the BEO, Block Education Officer, who is incompetent authority. I filed writ and also issued proposed punishments because I filed FIR against the BEO for harassment to SC candidates. The day I filed FIR, the day on 14th, and the IOC called to the day, thereafter he placed me suspension, and thereafter proceeding was initiated against me. And BEO is the incompetent authority issued proceeding against me. Your Lordship, kindly see the proceeding. That is Annex of 8, page 29.
So whether you have been dismissed or you have been reverted back.
They have, minor, as per CRCC appointment, they should, if any allegation is made, they have to revert me in the original post. Instead of reverting, they issued proper punishment for dismissal and forfeiting the pension, everything.
The order has been passed.
No, proper punishment. Before proposed punishment, I filed writ petition. Just after issue of proposed punishment, I filed writ petition challenging both initiation of proceeding and proposed punishment issued by the BO, who is incompetent authority. And the Honorable Single Judge, your Lordship, kindly see page 41 of the order. Held that BO is the competent authority in respect of a level 5A teacher. I am not holding the post of level 5A teacher. Your Lordship, kindly see the order, improved order, page 42, my lord, para 5. Relevant page, para 5. May permitted to place, my lord. Quoting the provision of Rule 6 of 997 rules, the Honorable Single Judge held that the BO is the competent authority. Against the line of the government, I filed a review petition that one annexer that is promoting the petition to level from level 5B A to level B was not produced before the Honorable Court. Therefore, I produced that even if I was appointed, promoted on the level 5B teacher, not A, but inadvertently I could not produce for reviewing the judgment.
Huh?
For reviewing the judgment.
You filed review.
Review.
That
My lord,
has been dismissed.
that has been dismissed without any reason. The Lordship, kindly see the review order that is page 55.
Who is your appointing authority?
My appointing authority is district committee is 2 level, my lord. Selection committee,
There is difference between selection and appointment.
my lord,
So selection committee can be one and appointing authority can be other.
my lord. So far as CRCC is concerned, so
forget CRCC. CRCC is just a kind of deputation.
my lord, your Lordship, the level 5B teacher, the level 5B teacher is, your Lordship, I enclose the rule. Can we see?
Block education officer is the appointing authority.
No, your Lordship, can say I am reading the relevant rule. That is placed, my lord. I have enclosed, my lord. Page 47, your Lordship, kindly see.
Page 47.
My lord. Of Annex 11, that is Odisha Elementary Education Rules 997. Para 6, Rule 9, 5
Annexure
substitute.
11.
Page 47, my lord.
Annexure 11.
Annex 11.
Yes. What is that?
That is rule in para 6, your lordship can see, in the said rule in rule 9, just below 5, clause 5, your lordship can see. After its approval, your lordship got it.
Page 47.
My page 47,
Rule
para 6, A, B, after A, B, 5, my lord.
Yes.
After
After its approval by the Director of Elementary Education, the promotion from level VA to level VB, level B to level 4, I am not concerned, I am concerned to level B, A to level BB of the service. The district education shall make necessary allotment to the senior block education officer or block education officer and for issue of appointment orders.
So he is the appointing authority, the block education officer.
The district education officer shall make necessary
No,
allotment.
district made
Only-
Sorry, the district education officer just makes allotment. The BEO is required to issue appointment letters.
My lord, suppose my lord, government, in so far as government is concerned, government is passing order for appointment, although secretary is issuing appointment order. In all cases, additional secretary also issuing appointment order. That means, with due humble submission, my lord, is not the appointing authority. Appointing authority is the, your lordship, in the top it has been mentioned, after its approval by the Director of Elementary Education. Approval should be made by the Director of Elementary Education and allotment should be made by the district education officer. Thereafter, issue appointment letter.
Yeah.
Issuance of my humble submission, my lord, issuance of appointment order and appointing authority is different, my lord. Because here approval was not made before initiation of proceeding.
Appointment order cannot be issued by an authority who is not the appointing authority. As simple as that. All right.
My lord. Here, my lord,
Here is the rule specifically says that the appointment order has to be issued by the block education officer. And please see the Article 311. Please see Article 311. What is the language?
appointing authority is there. Here, my lord, your lordship,
come to the finding of the
my lord,
Honorable Single Judge, finding at page 42, para 5,
page 40, my lord.
page 42, para 5, Annexure 10.
Para 5, this is level by BA teacher. Subsequently, I got promotion to level B teacher.
Read it.
Even for level B,
Para 5 and 5.
BEO is the appointing authority.
That's what is the finding, 5.1.
And in the written notes, my lord.
All right. So as we have understood, Mr. Counsel, as we have understood, you question the very initiation of disciplinary proceeding against you by the BEO on the ground that he was not the appointing authority. Your stand has been rejected by the learned single judge. That is correct view.
Because in the CRCC there is a condition.
Forget.
My lord, they should revert, my lord. Revert back to the original post. And instead of which they issued proposed punishment for dismissing my service, my lord. And in CRCC promotion order, my lord, they issued the project director, project code letter. And we also times the tribunal judgment of the tribunal accepted by the, I have in the written notes before the honorable single judge I filed that BO is not the appointing authority.
That judgment, please don't cite it for us. Please show some respect to the.
No, no. That was accepted. I am saying that was accepted by the government. I am saying.
The appellant.
And moreover, the petitioner is a group C employee. BO is incompetent authority.
The appellant. It is the appellant's case that He is a, what is your rank? What is your teacher?
Teacher man, CRCC was continuing, well, continue as CRCC.
He was appointed as teacher.
Level 5, 8.
Initially level BA teacher.
Odisha Elementary Education bracketed method of recruitment and conditions of service of teachers and officers, bracket closed. Rules 1997, comma, amended from time to time, comma, in level 5A, 5 capital A, and was subsequently promoted to level 5 capital B, bracket A, bracket B. Stop. He was sent on deputation to cultural
That is cluster resource center coordinators.
cluster
No,
cluster resource center coordinator, CRCC. Stop. For on the allegation of some misconduct, a disciplinary proceeding came to be initiated against him by the block education officer. Which block? Which block?
that is my lord, block education Contapoda in the district of Kotak.
Contapoda. Contapoda. Stop. The appellant filed a writ petition questioning the very initiation of departmental proceedings by the block education officer on the ground that he, not being the appointing authority, did not have the jurisdiction to initiate departmental proceeding. Stop. The departmental proceeding has admittedly reached the stage of issuance of so-called notice to the appellant on the point of proposed punishment. Stop. Next, rejecting the appellant's contention that block education officer was not the appointing authority, comma, learned single judge by an order dated 26/2/2024, passed in WPC number 9982 of 2023, dismissed the petitioner's writ application, which order is under challenge in the present appeal. Stop. Learned counsel appearing on behalf of the appellant assailing the impugned order has drawn our attention to Rule 9. Do you have Rule 9? Rule 9.
Rule 9 5 plan.
Rule 9, bracketed 5 of the rules to contain that it is evident that the district education officer is the appointing authority. Stop. Rule 9, bracketed 5 of the rules reads as under. Stop. It is apparent on reading of the said rules that after selection of that after there is no dispute that block education officer is the appointing authority for teacher of level 5A. So stop. It is evident on plain reading of Rule 9 bracketed 5 of the rules that after selection for promotion is completed by a committee stipulated under the said rules, comma, the district education officer is required to make necessary allotment to senior block education officer or block education officer for issue of appointment orders. So it is evident thus that the appointment orders under the rules are to be issued by the block education officer, even for level V, level 5 or V, level 5 bracketed B. So stop. Next, we do not find any merit in this. We do not find any legal infirmity in the view taken by the learned single judge rejecting the appellant's contention as regards the competence of the block education officer to initiate departmental proceeding against the appellant. Stop. We do not find any merit in this application and this appeal, which is accordingly dismissed. Yes.
Item number 7.
May I please your lordship. This is the lead petition public interest litigation. This is the second round, my lord. Earlier, the petitioners came before this annual court, and this annual court lost the initial proceeding and remanded the matter for the take decision for de-reservation proceeding, my lord.
With that order.
That order, it starts from Annexure 7, starts from page 43. The relevant page is 53.
Relevant page is
53. Para 16, my lord. Where is it? The sum total of the above discussion is that the de-reservation of the land in question, which was Gochar land to Bagayata 3, has happened without following procedure outlined.
You are reading which
Page 53, para 16. my lord.
16, yes.
The sum total of the above discussion is that the de-reservation of the land in question, which was Gochar land to Bagayat 3, have happened without following procedure outlined under section 3A of the Orissa Government Land Settlement Act, relating to the of the OJLS rules. This illegality is not a clear as far as the subsequent action of the annexation of land in question of the and the subsequent handling over the land in favor of the appellate party number 9 are concerned. That would be irrevocably legal result of the finding of this court, but the procedure of the for the reservation of the land in question was not followed. This was the finding of this law. Thereafter 17 minor. The question when arises as to what will happen herein after. Proceedings will be now take steps in terms of section 3A of the OJLS Act, where the 4 of the OJLS rule, but it will be made by the SEO to take record that the person of the land in question should be recorded by 3 as valid and honest. As a result, the status quo until that committee of the SEO will record will come into being in which case the land in question will be treated as of now as Gochar land. Steps will now be taken therefore Under section 3A of the Ordinance Act, Road and Rule 4 of the Rule, for de-reserving the Goshen land in accordance with the law. If there is any other legal requirement to be complied with in connection with the land in question prior to its alienation in favor of the IRCO, then that procedure also be complied with this by the state authority. The court expects that the steps to comply with the procedure for de-reservation in accordance with law will be completed in a timeline manner. It is made clear that till the proceeding is complete, status quo as of today will be maintained. Thereafter, will the villagers of the Gosa Puri we have filed that writ application. Thereafter, they started, pursuant to this, they started the reservation proceeding that is the under annexure 1 series. Page 23. Rule 3A of the OGLS, may I take your lordship, Rule 3A of the OGLS Act, my lord, which reads as like, the power to de-reservation of the land. The government may by notification of the official gazette authorize any officer not below the rank of a collector to de-reserve any land which has been reserved under clause A of section 3 or any government land recorded as gochar, where gochar land has been recorded, or any portion thereof. Any officer authorized under subsection 1. And my first question, there is no such state government notification in official gazette authorizing the collector or the above any officer. That procedure has not been followed. Thereafter, any officer authorized under subsection 1 shall subject to such conditions and limitations as may be prescribed have power to de-reserve any land referred to in that subsection or any portion thereof, if such officer is satisfied, such land or portion thereof as case may be, is no longer be prescribed to it. That has not been followed. And
This is for the members of the bar,
yes, ma'am.
that if you have to cite any statute or
Yes.
any book
Yes.
or anything, you should furnish that in advance to the court master.
So that they can easily
Otherwise-
take it out.
Otherwise, you are
Oh.
referring to some provision here.
Yes, yes.
We cannot read.
Well,
it.
I am sorry.
So, no, you are not
Beforehand,
saying
you
this is
just write item number and give the number, list of books you are going to rely. So that they can take it out and
the judgment,
judgment and book.
the bear and the, you can just. this. Yes, which provision you are reading?
That is section capital A of the Odisha Government Land Supplement Act 1962. And the rule, so there the rule have been
Capital A is there.
Capital A.
Capital A is no.
Second.
Land Supplement Act.
So it was three capital A introduced.
Yes.
Odisha, Achal.
Yes.
So let's
Book
look
is there.
Sorry.
Yes.
Yes, it is there.
Yes.
Yes. By notification, in the official gazette, authorizing any officer not below the rank of
This has
collector.
not been done.
That has not.
All right. So
And
just a minute. So therefore, there is no question of de-reservation.
there is no question of due date.
This is your
My ground is that the procedure as per the prescribed statutory prescription has not been.
no. This is most fundamental. If according
Yes.
to you, there is
Yes.
the
Thereafter, the rule four.
yes, you file your affidavit.
Yes, I find.
This liberty was granted by the court to
Yes.
proceed in accordance with law, particularly 3A is written. You have
Yes,
to
sir.
follow 3A.
And where with the rule four.
Let us see. Let us.
Yes,
We'll file an affidavit.
yes. My lord, there is an interim application for
Let us. The PIL will see. What is going on there after reservation? Some.
now they have proceeding for construction, therefore.
Yes.
Two.
They have already cut down the trees grown in the.
It has been leased out to IDCO, and IDCO has given in turn for construction of DAV public school, my lord. For construction of a school, my lord, 5 acres of
That
land.
has already been declared invalid because of this.
So the construction is on.
My lord, that I'll take instruction. There was on the earlier order also, my lord, there was a status quo in the previous case, so
In that case, status quo was there.
so what,
List this case on 4 weeks, 2 weeks, so as to enable learned counsel for an AGA
yes, my lord.
for the estate to seek instructions and file counter affidavit. Learned counsel appearing on behalf of the petitioner in the present writ petition in the nature of public interest litigation has drawn our attention to section 3 A of 3 capital A of the Odisha Government Land Settlement Act 1962 bracketed OGLSA in short, to submit that the government has not issued any notification in official gazette authorizing any officer to de-reserve any land which has been reserved under clause bracketed A of section 3 of the said act. Full stop. He submits that in the absence of any notification, no authority could have taken a decision to de-reserve any gochar land. Full stop. In view of the said submission, we observe that the parties shall maintain status quo if it is found that there is no notification as contemplated under section. Notification published in official gazette as contemplated in section 3 capital A of the act. So if you are satisfied that there is notification,
Then we, yes, sir. Oblige.
but in the notification,
Of the resolution.
VA and rule 4 of the OGLS,
OGLS rule,
OG Odisha, so and so rule 2013,
1983.
83.
Oblige.
April.
Item number 28.
Please, your lords.
Item number 20, lawsuit directed me yesterday to take instruction in the matter at 12 o'clock. I've talked to the officer. In fact, there was a direction to pass a speaking order, but they are not today. In fact, they are going to pass the order today itself. May pray
Tomorrow.
on Monday.
Take up the matter tomorrow.
Tomorrow.
Working day also may take it up. Yeah.
Tomorrow.
Item 30.
It's in item 30 here, prayed for last 2 months' time to dispose of the, because there was a direction to the honorable by the Sound Court to the right to dispose of the appeal filed by him. He has prayed for further 2 months' time to dispose of the appeal. He has requested lawsuit to make a mention. So you can also
Take 2 months.
2 months.
When was the order passed?
Not sir.
Order was first order was given 3 months time on 22 to 23. 22nd to February 23.
All right.
Again,
And what is this? What post does he hold?
that is the dismissal of a teacher.
What post does he hold, Mr.?
Director of Secondary Education, Lord.
So we will restrain him from discharging any duty till he decides the appeal.
But I came to know that he has
Just a minute.
Lord, sir. Lord,
So
sir.
he shall, the order was passed in March,
No,
3 months' time was allowed.
right, Lord.
Now in February 2020, that order was passed in March
Again.
2023.
Yes,
In
Lord.
February, in April 2024, he is seeking 2 months' time to dispose of the appeal. Then we will restrain him from discharging any duty. He shall not discharge any duty till he disposes of the appeal.
Where is the question of second contempt and all? The first contempt you short
No,
time,
no,
then
no,
you are bound to do it.
Yes, Lord, Sumer said by the end of this month, he will dispose of failing which is subjective of Lord Sumer said that.
My lord, this is the matter of 97. And in 97, I am suffering. I am running. That appeal is pending from 97.
As you wish. He should not discharge any duty till he disposes of the appeal. It's not a joke, the court's order.
Right, Lord Sumer, correct.
He is the same officer in item 28, same officer or different?
No, different officers.
Where is the order?
No, sir. Remind.
Always
Always
I quoted in page 5. of
Page
my-
5.
of mine. First order is 22nd to 23 and paragraph 3 last. The limited grievance in the present, in the past in writ appeal. I'm reading that the limited grievance in the present writ appeal in the appellant, who is in the opinion number 5, before the learned single judge double piece number so and so, is that no time limit has been fixed for the Director of Secondary Education Orissa to dispose of the matter. The impugned order is accordingly modified only with the addition that if the parties appear before the Director of Secondary Education Orissa through their authorized representative on 3rd April 23, after hearing them, a reasonable order shall be passed by the Director of Secondary Education Orissa within a period of 2 months. That was the first time. Second, Your Lordship, again, I file a first contempt, and that is paragraph 5. That in view of the above facts and circumstances, and specific in view of non-compliance of order dated 30th 3/20 passed in WP so and so, and 22 to 23 passed in WA number 469 of the petition of file content petition bearing number so and so for initiation of a content proceeding against the, that is my content, opposite party, which was disposed of on 12/9/23 with a direction to the contender to comply the order passed in WPC number so and so and WA number so and so within the period of 3 months from the date of production of certified copy of this order. The said order dated 12/9/23 is quoted below. That is the order. This matter is taken up.
Where are reading?
My lord,
Where? Yes, 7.
In the petition.
Yes, when. That is the second order
In
passed in
petition
contempt.
you have reproduced.
All the orders.
In the second contempt, 2 months was given.
Page 5.
In paragraph 4, let the opposite party comply with the same if not already complied within meantime within a period of 2 months from the date of communication, production certificate of this order.
There is a typo. Within a period of 3 months, it's missing.
First was 3 months, then. Mistake. That is the order. That is the order. Second contempt order.
Your case.
Yes, Lord.
Yes, imprisonment.
No, here what is
Oh,
happened?
fine.
The present incumbent has joined on second of April.
Present incumbent.
No, I am not saying that. So Roshi may only say by end of this.
Present incumbent shall not be punished. Because present incumbent has not committed contempt.
Correct, but
The contempt has been committed by him. What is his name?
the details.
He has to purge the contempt.
No.
Who is the gentleman?
My friend must have given.
Prashant Kumar Das,
Yes,
Where is he posted?
Director Secondary.
that I have to take instruction.
The facts emerging from the materials on record shocks the court's conscience in a matter which is glaring and shows blatant disobedience of two orders of this court. First off, a coordinate bench of this court, while disposing of WA number 469 of 2022, had passed the following order on 22/2/2023. Quote the order. As the aforesaid order was not complied with, the petitioner filed a contempt application giving rise to CONTC number 6652 of 2023, which came to be disposed of by an order dated 12/9/2023, which reads as under. Stop. Learned AGA, appearing on behalf of the state contemners, upon instructions, informs this court that it will take 2 months further time to dispose of the appeal.
Yes,
Appeal.
Dispose of the appeal
Hearing
which
number.
is pending before the Director Education. Full stop. Next. It is apparent on reading of the two orders noted above and the fact that they have not been complied with, comma, in our opinion, a gross case of contempt of court is made out. So stop. List this matter on 2 weeks. On which date the contemner, opposite party member,
only opposite party.
On sole opportunity.
Sole
the
opposite party.
contender shall be required to be personally present in court. So stop. The court will consider disposing of the contempt proceeding summarily on that day. I will put him on trial.
Yeah.
May person that,
Yes.
sir, that appeal number, if you that is appeal number.
Why is the number there?
It is about 99,
That is not required.
1997, I'm looking.
All right, let them find out.
Appeal number 1332 of 1997.
Yeah, appeal लिखा है ना? Appeal number 133 of 1997.
1332 of 1997.
1332.
133
Paragraph 1 I have put it.
of 1997. Yes.
Item number 8.
May I please your lordship, my lord, kindly taken the matter after 1 week
Why 1 week?
due to some instruction.
As requested on behalf of the applicant. This matter on 1 week.
Item 9.
Obliged.
May I please, Lordship? It's a matter relating to public interest litigation, my lord. Here, the deity property is under unauthorized construction and encroachment. Earlier occasion, the petitioner approached this honorable court, and this honorable court granted liberty to make a press representation. Accordingly, this press representation was submitted, and your lordship will find from the inquiry report done, which reveals that the allegation of the petitioner is true, that your lordship will find page 26, your lordship. Page 26, the relevant portion is page 27 and 28. I am reading that. In reference of the aforesaid letter, I directed IE, ASCA and Kodala.
Reading page 26, 27.
27. In reference, you lordship got it? In reference to the aforesaid letter, I directed IE, ASCA and Kodala, in charge IE Chhatrapur, to visit and submit report. Her report states that the institution is a public religious non-indexed institution managed by Sudhanshu Shekhar Pandya Sachans. The institution has land in Damodarpur Mauja under Ranjan Tahsil bearing khata number 62 and plot number 22, 24, 28 and 54 having an area of 3.593 decimal. The report of the IE Chhatrapur reveals that one HP domestic LPG gas agency is being run in the name of Suman Enterprises by Sri Santosh Kumar Mahapatra, son of Sachanchas, resident of Durga Devi Street, Ganjam, has obtained acres such and such over plot number 24 of khata number 62 of Mauja Damodarpur Tahsil, Ganjam, from Vishwanath Gowda, son of late Nattavar Gowda, who is neither the recorded holder nor the markholdar of khata number 62. Similarly, a double-stored building is constructed.
Which are the act? 19. Yes.
Similarly, a double-stored building is constructed over plot number 28 over the aforesaid Mauja by one Sudhir Kumar Pari, son of such and such, resident of such. All these encroachments are in contravention to section 19 of the OHRE Act 1951. Thereafter, this report was. This is the Additional Assistant Commissioner Endowment Barampur's report letter, my lord.
At
And
no
this-
point in time, section 19 was resorted.
No,
No permission from 19.
no. And the detailed inquiry report to the inspector of the endowment.
They make questions. So is there any dispute with the judicial mechanism under the act? No.
Under the Endowments Act, section 25 can be resorted to. Yes. The commissioner,
Encroachment.
yes, Endowment Commissioner can make a requisition to.
25 is there.
Yes, Lord, 25 is there. It can make.
Why should he come to the High Court?
Right, so.
Resort to 25. The removal of encroachment.
My lord, here
You have to move an application before endowment commissioner.
petitioner is not the Marfat Dharma.
25 months.
25 of Marfat Dharma করা
No, this is within his knowledge. He can initiate
Yes, no.
action.
Act says any person not.
Any
Himself, so he can start.
Anybody not.
After this report, he can so to start.
But that has not been done. Though the report is of the year 2023, 2023, my lord. In the meantime, already 5 months have been, 6 months have been passed.
The civil suit is also contemplated. Any question I require.
After that. After that. So, endowment commissioner to be collected. Petition in the nature of public interest litigation has been filed alleging inaction on the part of the opposite parties and thereby failure to protect the endowment properties at Sri Lakshmi Narayan Swami Vijay in Rajapur. Which is a religious endowment within the meaning of section 3 bracketed Roman 12 of the Odisha Hindu Religious Endowments Act 1951 bracketed OHRE in short. From the pleadings on record, it appears that you had earlier approached.
Yes,
Where is that order?
that order I have quoted it at paragraph
That the
page 8 of my petition
had earlier approached this court
in WPC
alleging
218.
same grievance, giving rise to WPC number 21823 of 2022, which was disposed of by a coordinate bench of this court by an order dated 29/2022 with the following order. Stop. Pursuant to the said order, the petitioner is said to have made a first representation before the opposite parties, whereafter an inquiry was directed to be held. Stop. The petitioner has brought on record a communication dated 28/10/2023. 23. Page 27 is 28/10/2023. 28/10/2023. From the office of the Additional Assistant Commissioner of Endowment, Behrampur, addressed to the Commissioner of Endowments, Odisha, Bhubaneswar, which the body of which reads as under court custody. Paragraph 1, paragraph 2, and paragraph 3. That body of the at page 27. So, next, learned counsel appearing on behalf of the petitioner has submitted that despite clear finding recorded by the additional assistant commissioner of endowment in the said communication dated 28/10/2023 to the effect that the encroachments are in contravention of section 19 of the OHRE Act, no remedial measures have been taken. Stop. Next. Section 25 of the OHRE Act makes provision for the recovery of immovable trust property unlawfully alienated. Stop. It stipulates that in case of any alienation, in contravention of section 19 of the Act, or in case of unauthorized occupation, or के बाद लिखना वो underline करते हैं, or in case of unauthorized occupation of immovable property belonging to or given or endowed for the purpose of religious institution, the commissioner may, after summary inquiry as may be prescribed, and on being satisfied that any such property has been so alienated or unauthorizedly occupied, send requisition to the collector of the district to deliver possession of the same to the trustee of the institution or a person discharging the function of the said trustee. Next, in view of the communication dated the communication dated 28/10/2023 casts an statutory obligation on the, he is called endowment commissioner, on the commissioner.
Commissioner of Endowments.
On the commissioner appointed under section 4 of the Act, of OHRE Act, to proceed in accordance with the provision under section 25 of the said Act. Stop. This application is thus disposed of with an observation that the commissioner appointed under section, that let the commissioner appointed under section 4 of the OHRE Act proceed in accordance with law in the light of the findings of the inquiry conducted by the additional assistant commissioner of endowments, Bharat Rampur. The inquiry was conducted by him.
Inquiry was conducted by the inspector of endowment, and it was the
He submitted a report.
Inquiry conducted by the inspector,
endowments, ASCA,
by the inspector of
endowments,
endowments,
ASCA and Kodola.
ASCA and
Kodola.
Kodara. Mentioned in the said communication dated 28/10/2023. All right.
I have also made that endowment commission will also indicate that opposite of on party number 3.
And we know. Yes.
Item number 10.
For grant of NOC petitioner applied for the academic session 2023-24, my lord, with all the documents, my lord. For grant of NOC opening the BSc nursing course, petitioner applied with all the documents and required fees deposited and
For which academic?
for session 2023-24.
So what can be done now?
My lord, already granted on 23-24, my lord. They have granted page 33, my lord. My case is, my lord, page 33. They have granted on 16/1/24, my lord. And by that time, the session for renewal of 2024-25, that is over. That's why my application is not accepting on the plea that the period has been over, my lord, for renewal. But petitioner has no latches, my lord. On the latches, on the matter of the
Mr. Ansel, the High Court cannot extend in view of the observations made by Supreme Court.
Not exam, but petition has not accepted the, I will let them consider my appeal unnecessary,
Cannot,
my lord.
they cannot consider.
Petition has no latches, my lord.
We
We have page 35, my lord, I have glanced page 35. my lord.
we are duty bound to follow law.
Page 35, my lord.
Sorry, nothing can be done now.
Page 35, my lord. Yeah. The last stage of online apply for renewal of NOC for existing institution under the Council of Nursing, Pharmacy, Occupational Therapy and Physiotherapy, DMLT and DMRT and Allied Medical Science for the session 24-25 is hereby extended from 61-24 to 21-24, madam. But the petition received on NOC on 24 January 24, madam. That's that.
Nothing can be done.
They can consider, they can consider.
My lord, I have deposited huge amount, my lord, and also admitted students, my lord. If you know, petitioner will
You admit students without NOC.
NOC granted, my lord. NOC granted 23-24.
No, NOC was granted.
Granted, my lord.
Yes. So NOC is not enough.
No, my lord. NOC I have granted, my lord.
NOC is just NOC. How can you admit students without recognition? You will have to refund the fee. If you have taken admission, you please refund fee.
The accounts, but I have deposited fees to the council, my lord. DMLT and for NOC and also.
How could you admit students? You are saying you have admitted. How could you do that? That can be a matter of inquiry.
The students' careers are in jeopardy because of.
You will have to refund the fee. If you want, we can entertain this application for that purpose. As you wish.
No,
File.
no,
Why?
no, I don't.
Why no?
I don't.
We will decide your matter on merits.
My lord, counter file.
Counter, yes, counter also on the point as to whether you have admitted students or not
My lord,
without recognition.
my lord. Let them file counter.
Where have you said that you have admitted student?
Not admit, I have not said.
Then first of all, you say this.
I haven't.
When counsel appearing on behalf of the petitioner states that if the renewal of NOC dated 24/1/2024 is not taken into account for the academic session 2024-25. Who is the petitioner? The petitioner institution shall suffer irreparable loss since it has allowed admission to students to this course. Stop. Let a supplementary affidavit be filed stating as to in what circumstance and how many students have been admitted despite grant of recognition. In the absence of recognition granted by the who grants nursing council. Odisha?
Midwives, nursing and midwives registration council.
Odisha nursing
Midwives
and midwives
registration council.
registration council. Sorted. Does this matter on 2 weeks? File your affidavit.
Item 11.
And for DLT and governance.
How are they admitting students? What are you doing?
No matter he has not cannot admit students without getting the affiliation and the recognition.
What are you doing?
So, my lord, he has not applied for. We have given only the NOC.
How are they admitting students? This is what we are asking.
No, 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 this has not got to our knowledge that he has admitted students.
All right, do it.
Item 11.
May I please? The petitioners are challenging Rule 4 of the constitutional validity of Rule 4 of the Odisha Group B, Group C, Group D, repeal and special provisions rules 2022 alerts. In Odisha Group B, Group C, Group D, repeal and special provisions rules 2022 alerts. That is under Annex 19, page 161. In similar batch of cases, your lordship already has issued notice, your lordship, and the matter has been fixed to 9th of April, your lordship. So I pray this matter may come along with those matters, your lordship.
Where's that order? That matter is coming.
9th April. Similar matters are coming on 9th April.
9th. It is stated at the bar that certain writ applications involving legal issues as are involved in the present writ application, including WPC number 9791 of 2023 has been directed to be listed on 9/4/2024. So list this matter on 9/4/2024 along with the WPC number 16303 of 2023 and other analogous matters.
I love that.
Item 12. My lord, item 12, sir. New facts have been brought to our notice. Let's say, I pray for an adjournment so that new facts can be brought on record.
Indian Nursing Council, they made a party, let them serve a copy also.
We'll submit the possibility.
Let requisite number of writ application be served upon learned counsel representing
Indian Nursing Council.
Indian Nursing Council.
OP number 3 might have. Yes.
in course of the day. List this matter on. When do you want?
1 and 2.
Union of India 1.
1 and 2.
Well, yes.
When do you want?
Let's do any day next week.
1 week.
Item 13. Okay.
For 4, 5 and 8. Four, 5 and 8. I am from director and registered council.
Have you served?
No, only one copy has been served to me. I am for
Yesterday night we had served.
another 2 copies to be served.
We served it. Okay.
I may please your lordship, madam.
Item number 13.
I may please your lordship, madam, virtual mode, madam. The petition for lordship is appearing for lordship for hardly 1.5 years.
Item number 15.
Item 13.
Are you ready? You have written 9.
I'm sorry, madam. It is
You
13.
have written 9.
May I say the name of the petitioner, madam? Neeraj Kumar Singh.
Yes, Neeraj.
And I may be allowed to make a submission because there is a lawyer before lordship for 1.5 years. While he was prosecuting as a student of law, he had written annexure 3, page 19 to the government to include the dynasty of Kalinga and the culture and other things, page 19, my lord, annexure 3 to the government while he was prosecuting his study as a law student in 2021. Page 19, my lord, prayer was that must be a systematic studying from standard 6 to standard 10 in relation to the history and culture of the, that was, my lord, His Excellency. Lordship, can you turn to page 21, my lord, annexure 4. Annexure 4, my lord, page 21.
So what do you want? What do you want us to do?
What is your prayer?
Page 21, annexure 4.
What do you want us to do?
To let the authority consider, but I do not say anything of pros and cons or argue on merit that whether it will be included or not. But consideration only is always a matter of right, madam. Therefore, mandamus.
What is the matter of right?
Everything, being a citizen, my lord, I have a right to make a representation over the authority for any concession, maybe rejected, maybe allowed, maybe legal or illegal.
Where is that?
My humble submission is.
Where is that fundamental right or legal right to make a representation?
It can be derived from that of principle of state policy also, madam. This so far present application before lordship is concerned. So far present application, I can derive it from the direct of principle of state policy, madam. His Excellency has also forwarded, madam.
So what do you want us to direct disposal of representation?
Yes,
This is the last thing which we will do.
I don't want to interfere or any to make any submission on whether it should be or should not be at this stage, madam.
Sorry. Presentation. And where is your representation? Let us see.
And in vernacular, it's page 17. Translation is at page 19. And communication I have given by that page 18. To follow the PIL format, my lord, as your lordship decided that what should be the format of the, you approach fast to the authority. That is always right, my lord. I bow down before lordship, my lord.
In page 20, what have you said?
Let them consider, examine the matter. What I'm trying to convey to lordship is the anxiety of the boy is the petition for lordship, who is a hardly 1 and 6 year practitioner before the honorable court. That there be systematic introduction, inclusion of the history of Kalinga, like Kharmar, my lord, like in Odisha.
Mr. Mishra, we have restrained ourselves from making any comment.
No comment is required.
No, even for that, why should we direct for consideration of your representation or disposal of your representation? If something is there which we can adjudicate upon, we will adjudicate upon. If something, otherwise, just you are filing representation and you are seeking a direction for disposal of representation. This is not right.
Already His Excellency had sent this representation to the Chief Secretary for consideration. So there is absolutely no.
Let them examine the matter. both the interest of the state as well as the people of Odisha.
Lord Senior Counsel appearing on behalf of the petitioner has drawn our attention to a representation said to have been filed by the petitioner before the Principal Secretary, School and Mass Education Department, Odisha, Bhubaneswar, and has submitted that this court should direct the Principal Secretary to consider the said representation and dispose it off in accordance with law. Stop. Next, we have carefully perused the representation and pleadings on record. Stop. We do not find any reason to issue such direction for consideration of a representation in the representation. Stop. We do not find any merit in this writ application, which is particularly dismissed.
Item note 14.
Obliged. Obliged, madam.
Yes.
So this is very better. For the petitioner challenge, there are two notifications by direction of 9 and 11. Those are bills 5/7/22 and 31/23 bills. Of course, also 168 of the GST Act bills. Very same matter of the very same petition on bills. So Lordship has issued notice and requested my friend Mr. Pari to appear on 9th of April only. And to respond to the petition. And I also passed interim direction, protect the petitioner with respect to take courtship action. Yesterday also, you also have taken up one matter. All matters, yes, you also been directed to call on 9th of April matters. One petition of yours.
Is this matter? How many cases?
One. Today, how many cases?
Today only one yes. One more matter, this petition there, that is likely to come with us either tomorrow or Monday.
List this matter along with WPC number P703.
Yes, 3703 and also 1728 of 2024.
2024. And other analogous matters.
1728 of
which involve, which admittedly involve similar questions as are involved in the present writ application. On when those matters are coming on 9/4.
I am appearing on behalf of Mr. Sarfati. Let's have given memo of appearance.
Item 15.
Let them serve a copy of this and then I can have an instruction.
How solve that?
Item note 15.
Item 15, Lordship, in the first item, I am appealing for the alleged contempt, Lordship. The Soper's reply has been sent to get it signed, Lordship. Lordship may call this matter next week any day. I will find it out. Soper's.
Now let us see where is the order.
Not okay.
Lordship this is an order. I am appearing in item number 3.
Yes.
What happened, Lordship, can you see? This is an order disposed of in the admission stage. The matter was disposed of in the admission stage. Lordship, can you see page 8 and para 4 of that content petition? Lordship, can you see? Earlier also 2 to 3 matters came before this summary report.
lawsuit also passed some orders. In fact, there is no trade license, no street vendor identity card is there. So in the admission stage, without hearing the municipal or municipal corporation, order was passed. That is why lawsuit said that a show cause to be filed. So we filed show cause, and in fact, the matter was not had by the municipal corporation. So we can see, I mean, that was
Just a minute.
case 8, para 4 lawsuit can be.
What is wrong with this? There is a, you are.
In that paragraph 4 lawsuit, the Honorable Singh just said that without hearing the municipal corporation, order was passed. But in fact, he has no trade license, nothing was there. He misled this honorable court and said that this order was passed. So the lawsuit can listen to 2 to 3 matters came before this honorable
Let's
court.
come to paragraph 4.
Yes, sorry.
We are satisfied that CNC is aware of petitioner being a vendor at the vending site.
Yes, in fact, he has no trade license and
Maybe he may not be may not be having trade license.
yes,
For which he was issued a forced document. Which document?
the document he has not annexed, my lord. That's the whole problem. In last, in other, on other neat applications or documents are annexed. So in 2 to 3, you could have filed a review application. The review application is correct, but you have not filed a review. This school judgment is binding. Also,
If they misled the court, it was not issued.
that's true. In admission stage, the matter for you should have fought for review. That's correct. Last in the connected matter, also we can see the order. It's kindly see. In last article, similar matter, 4 to 5 matters came. I mean, exactly same matter. Second one that was prostrate for filing of show cause and other things. Yes, there is nothing. That's not. So file show cause also. File show cause. What is the?
You don't have any explanation.
No, no, no. The second one that was posted, so later all matters will come in second. They will file review. And how do you?
We are not sitting in advisory jurisdiction.
No, no, that's it. That's correct.
We are making this observation. Just as requested on by the parties. List this matter on. When is that matter coming? Second.
3 items. 3 items are there.
Along with. Just go.
Item number 16. But I'm so sorry, Lord. Item 13 not also was the interim order, because it was there in the order. Probably it was missed from my lords.
In the meanwhile.
Yes, I was 5. Yes, regulation.
Last item 14.
Item number 16. My plea, the lordship. The petitioner who has retired, I understand engineer, is not getting pension because when he was working under Barampur University, there was certain irregularities in his service.
No, no, where is the order which has been disobeyed?
Annexure 1. If it was pending, it was disposed of, but other than new steps have been taken. In the process, I am deprived of getting my pension and pension benefits. Government, in annexation
Petition, your rate petition had become infructuous.
in annexation 4 also,
Your rate petition, according to that order, had become infructuous for all purposes, as no cause of action remained for adjudication. But that representation part was, have you considered?
the annexation 1 order has not yet been implemented. Annexation 1 order is pending.
Grievance.
Irrespective of the fact that annexure 4, the authorities have implemented the procedure to ensure that my service is regularized. Still then nothing has been done. Annexure 4, page 13.
Who is for the other side? Who is for the other side? University?
University must, it's independent body, notice has to go, we cannot appear now.
They should notice.
Item 17.
This case, we are in the process of complying with lawsuits order.
May I please, moment.
Yes, we have complained lawsuits order. An excellent, yes, intimation given to me. I find that affidavit will also collect next week only.
Nobody can comply with it.
No, my lord, I think what my lord, one lord is related to payment of escalation. They say they have complied, someone is under process, lord. They do come up. Next week, lord.
What is the instruction? That the
instruction.
court order has substantially been complied with. So, he intends to bring on record the compliance report by way of affidavit. So, this is matter of 1B. Easily by the affidavit must be filed. Filed stating compliance of this court order.
Item number 18.
That petitioner filed a contempt application. Was the order dated 7/7/2022 as per page 13. The order starts at page 13. Has not been complied with. I have initially approached again in a contempt proceeding. The Honorable Court granted some additional time to comply with the order, but irrespective of granting additional time, no compliance has been done. This is MCL, Millets.
Honorable Coalfields Limited,
They have a different panel, the notice has to go, and the panel has tried to serve a copy, but they said after notice they can only appear.
Who has to comply with that?
Opposite recommending Mr. General, the general manager, my lords, because at the present time, I have submitted my bid on the call of the general manager. He had forfeited my EMB. Direction was there to release the EMB. General manager did not comply. I am leading party in person, some department.
General manager of which company?
NCL, my arbitration limited. We have an office at Bulla, Samipur.
50,000. 50,000.
Lakhs,
50 lakhs.
Item 19.
Not close.
Item 19.
Item 19.
Are you in 19?
Second content, my lord. Page 30. The first order has to comply the order within a period of 3 months, my lord. That was communicated on, my lord, 6/10/23. Till date, they have not communicated. Till date, they have not considered, my lord.
And to the end concern, copies of
In post students of copy.
Who has to comply?
My lord.
I am from the Commission of Endowment.
Commission of Endowments, my friend appears for him. Commission of Endowments.
So that I take instruction whether comply or not, my lord. A copy of my lord. Yes, ma'am.
So as to the seek instructions and inform this court as to whether this court order is of the right company and comparative.
Item number 20.
Item 20, lordship.
Yes, sir. That is lordship's order has been complied with. The record of right has already been published in favor of the petitioner. I am giving you a copy, lordship.
It's stated at the bar. That is the court order. By the chair of which has been available to the petition. As they comply with petition stands this court order. Inside the order. Yes.
Item number 21.
May I please, Your Lordship? The petitioner had challenged the order passed by single bench. Matter is relating to pension and pensionary benefit. In the meantime, petitioner has been died and substitution petition has been filed. IA number 3619 of 2023.
No, no objection. Will the thing from the other side?
I am.
Again, it's one line of. substantial of the legal years of that is the of also and has defined right authors of the legal years of the facts and circumstances of the case. This is one line of 2023 law. That name of the daughter husband at this time will be strike off. Do we strike off the names? Do we strike off the deceased party or?
We'll file a consolidated court file. Right? Only court title.
Legal years, description of this litigation. For the purpose of proceedings. This constantly, right? On behalf of the what should be the system? Even can you, when a person dies, then he has to be substituted. Then what should be the course?
You normally it is shown as dead and then below him serial number 1A, 1B
Represented.
that's the civil side practice. Other course would be just to strike him off and have a
Substitution means that only.
You have to substitute completely, removing.
normally the cost item says that person since dead and then below him the name.
That is also.
These are the two forms.
We will examine that aspect later.
Item number 22.
Application for restoration. It was on 2/2/2023 due to non-appearance of the advocate for the appellant. That's
What was that?
and notice was issued. Pursuant to the notice, I am entering appearance for the appealing party. But my appearance may be accepted and I may be permitted some time to find the objection to the application.
Oh, the petition was just not the court,
Yes,
not appearance.
yes.
When
In the 2/2/2023.
2023, you filed in 2023. What objection?
And in time also.
What objection did you pass?
Formal objection I will file.
No,
As your lordship please, if your lordship permit me, then I will file objection. But my appearance may be accepted.
Where is application flag?
Yes, sir. That is the original application. Yeah. CMAPL is the main application and paragraph 2 is the reason. Number 320 of
2020.
520 or 320?
520
520 of 2020.
520 of 2020. Or on the basis of not appearance by an order dated 2023. Including the statements made in this application and in the interest of necessary agreement proper to allow this application in direct form information or number so please from this application
I have published.
Item number 33.
This my lord, the matter where this court is monitoring these overcrowding of jails. I'm appearing as an amicus here. I'm given a note for convenience. There is one issue since the time is short. There is one issue which your lordships may like to take it up on an urgent basis. Around 120 odd, I'm not getting the exact number. 120 odd under-trial prisoners, they are not able to go out on bail because of non-furnishing of bail bonds. Overcrowding is an issue across the state since COVID this began. If my lord would just see that note, which is there for today. We have highlighted the past orders. In the list, it says, at the bottom of the list, it says that short note for April 2024 filed by amicus is at top of the order sheet. Top of the order sheet. That's what our physical list says. It's a very bulky file, but if my lord would see that short note for today we have made.
Short notes for April 2024.
If that document my lord can see, we had circulated it. Now, this issue is something which is internal. Earlier also this court took up around 50 without bail bonds. Now it's crossed 120, 140. So these people have been granted bail by their respective courts. Yes, my lord. In fact, these are on the basis of reports by the district legal services authorities they visit. So on the basis of their reports, I have come up with a list. So that is something
because the stringent bail conditions.
My lords, and my lords, I have given a judgment of Justice Krishna in 78 and the recent one of Justice Kaur, where there is a mechanism for non-furnishing of bail bonds. That probably is not being strictly being followed because these people are there since last 2-3 months. The courts are not, so there's a general order also passed in this PI. Unless these people go out and the numbers are also increasing. Now in the summer months, my lord has to probably take this up on a priority basis.
So what are they doing? Whether legal service authority is a party or not?
Yes, my lord, he is appearing in this thing now. The secretary is there.
Yes, what are you doing? What are you doing for that?
Namaskar. My lord, so far as the December figure is concerned, my lord, out of that figure 120, 155 UTP languishing in the jail custody, 122 persons have been already been released on bail. And so far,
120.
so far as December figure is concerned, it is totally 155 languishing in the jail custody after granting the bail. Out of that, DLSA figures says that 122 persons have already been released on bail.
How many?
122
Out of 150, 122 released.
Yes, ma'am. Out of 155, 122 have been released. And the rest of the prisoners, my lord, there are private counsels and DLS secretary is apprising the private counsel to file the bail modification. And so far as legal aid counsels and defense counsel have been engaged for modification of the bail bond.
This issue cannot be.
And your lordship, there are also multiple cases. So these persons have not been released. In every month, my lord, as per the
Mr. Can you furnish us a list of such persons who are languishing despite the bail orders granted in their favor? From the date when the order was passed, the bail conditions and reasons why they are not being released.
Yes, ma'am.
Give us a chart of all such persons
Yes, yes, ma'am.
in tabular form.
Yes, ma'am.
All right.
Yes, ma'am.
On next Friday.
Right.
So we should rather the authority should fix a target that no such person should remain in jail.
Yes, ma'am.
So on Friday, you must tell us as to what can be done to ensure 100% compliance.
Yes, ma'am.
So we are just adjourning the matter today for next Friday. You keep this in mind. We will put the same questions again. Be ready with the chart. We will take this matter on topmost priority. Take up this issue.
Yes, ma'am.
For this relates to liberty.
Just one paragraph. This is called judgment. There's a SOP drawn for these kind of issue.
Next time. Next.
We are all grateful to you.
Silence. Be that as it may, in view of the nature of order which we intend to pass in the present matter, we refrain ourselves from recording any definite opinion at this stage that the impugned so-called notice issued by the DGGI is barred or not by virtue of operation of Section 6(2)(b) of CGST or GST Act. Considering the dispute raised in this regard on behalf of opposite party number 1 and 2, we see no reason why the petitioner did not respond to the summons issued by the DGGI, taking a plea that it was barred by Section 6(2)(b) of the CGST or GST Act. Further, in the present case, a so-called cum demand notice has already been issued on 29/12/2023. Such being the position, we decline to interfere in the present matter. The petitioner shall have the liberty to respond to the said so-called cum demand notice dated 29/12/2023 and take appropriate recourse to the provisions of the CGST Act. Since we have refrained ourselves from expressing any definite opinion as to whether the case of the petitioner is covered by Section 6(2)(b) of the Act, it would be open for the petitioner to take such plea before appropriate authority in appropriate forum. Yes.
Orders item number 2.
17352. Much. What is that?
The formal correction.
Which order?
Your Lordship, order dated 22nd February 2024.
22nd February.
Your Lordship, that is in the cause list of the
Office note it is taken.
The opposite party, name of the opposite party.
He corrected.
Yeah. Instead of Joint Commissioner of State Tax Appeal.
Your Lordship.
Should be there.
Office note territorial range will be there.
Your Lordship, that is at page 2 of my brief. Joint Commissioner.
No, what is the correction required in the order?
Lordship, the correction is required that territorial range Cuttack to Cuttack, the address. Your Lordship, in the cause list it has been given.
Cause list will not do when we have the record before us.
Actually, Joint Commission of State Tax Appeal Bhubaneswar हो गया है. Your Lordship, that is territorial links Cuttack to.
Which order?
Your Lordship, order dated 22nd February 2024.
Yes. Where it has been Joint Commissioner in the cause title?
Your Lordship.
In the cause title or in the order?
Top of the order, Your Lordship.
All right.
In place of Bhubaneswar, that will be Cuttack.
It has been pointed out that there is a typographical error in the cause title of the order dated 22/2024, wherein Joint Commissioner of State Tax Appeal Bhubaneswar has been typed in place of Joint Commissioner of State Tax Appeal. Territorial range Cuttack 2. Accordingly, it is ordered that the said order dated 22/2024 shall be read accordingly, and Joint Commissioner of State Tax bracketed appeal Cuttack.
Territorial range Cuttack.
Territorial range Cuttack 2. Cuttack Roman 2. Cuttack Roman 2 shall be read in place of Joint Commissioner of State Tax Appeal Bhubaneswar in the cause title. Yes.
Item number 3.
In this case, the spelling of the name of the petitioner, there was a mistake.
Is
Ashoka,
H is to be omitted. H is to be omitted. ASHOKA. It should have been ASOKA.
the name of the petitioner has been wrongly typed in the order dated 22/2024, in as much as in place of Ashok ASOKA. ASOKA.
Yes, sir.
ASHOKA has been typed. To top, the said order shall be read accordingly along with the present order.
Great. Item number 4.
your name is SD agency, the name is typed as SK agency.
Why is this happening? This is because our DMS is not good. These things are to be entered at the time of registration. placed for making correction in the typographical error in the order dated 22/2/2024, wherein in the false title, name of the petitioner has been wrongly timed as Messrs. SK Agency in place of Messrs. SD Agency. Stop. Let the said order be read accordingly, and in place of read accordingly. Stop. The present order, the order dated 22/2/2024 shall be read along with the present order.
Yes.
Item number 5.
May please, Mr. First, we are not pressing upon the interim application rules.
Yes. Dismissed as not pressed.
Deeply apologize.
this case, lawsuit should be to direct me to obtain instruction for regarding transfer of these records from the jurisdiction of Commissioner of Balester to Bhadrak Minas. I have obtained instruction because all the records from Balester to Bhadrak have been sent back, but he could not confirm the record because he was trying to find out the records. You will estimate, give me a week's time, in the meantime, I will confirm it. And what one problem is that your worship's order initially was there was a direction for transfer of an appeal mill. Now the IA is for revision, but your worship may not direct that. We will so much take up that matter. They will talk to them because all revisions are to be taken up by the Bhadrak jurisdiction. So automatically that will come.
Some order is required to be corrected.
Yes, that individual number also.
If you don't correct it, then if that is not pending, how will it be transferred?
Right, boss. So
9721. 9721 is the order.
only appeal number will be corrected and individual.
Para 5 and 6. Instead of that, let the government be file.
The order dated 9/7/2021. There is a typographical error in paragraph
5 and 6.
In paragraphs 5 and 6, wherein appeal number has been wrongly mentioned.
Appeal case number 20 of 1985 has been wrongly mentioned. It should be
Appeal case number 20 of 1985.
It should be consolidation revision case number 158 of 1993.
Wrongly mentioned in place of consolidation revision case number 148.
Yes. 93.
Of 1993. What about paragraph 5?
5 and 6 both.
No, but in paragraph 5, it is mentioned passed in appeal case number 20 corresponding to.
Yes.
That is
Subsequently, the above appeal case number 20 of 85 is remitted. It should have been revision case instead of appeal. It should have been because the commissioner hears revision. The director hears appeal.
No. In paragraph 5.
Yes, ma'am.
7th line, 6th, in 6th line.
Yes, ma'am.
Appeal case number 20 has been wrongly mentioned.
Yes.
Huh?
Yes.
In the 3rd line, appeal case number has rightly been mentioned.
Appeal case number should have been revision.
No, there's a consolidation revision is mentioned in the 4th line. So is it the same thing or that appeal case has to be deleted?
I'll read it and then I'll explain. Accordingly, the para 5, the improved order of the learned single is modified by directing the order dated 8/12/95 passed in appeal case number corresponding to consolidation. That is correct. But subsequently, while remitting it back.
Right.
Yes.
Right. This is what we are saying. Everywhere appeal case number is not to be.
No. Only the 6th line.
In the 6th line.
6th line, Malad.
In the 6th line of paragraph 5 and the last line of paragraph 6.
Yes, ma'am.
Wherein appeal case number 20 of 1985 has been typed in place of revision case number 148 of 1993. So, after having seen the records, we are satisfied that there exist typographical errors. So, accordingly, let revision case number 148 of 1993 be read. In 5 and last line of paragraph 6 of the order dated 9/7/2021 of 1985. This order shall be read accordingly. The order dated so and so shall be read accordingly. This revision, consolidation revision arose out of appeal case.
Yes. Because objection case, then appeal to the director, then revision before the
So
commissioner.
then both the orders have to be set aside, the
No.
appeal order and the.
The earlier order only has remanded to the commissioner, the revision has to be heard. What the earlier single judge had done.
Oh, all right, so appeal, then corresponding thing should be
It's confusing, but it's all right.
arising out of.
Further giving rise to.
Yes.
Giving rise to. Appeal.
Then that means that appeal case is not set aside.
No,
But in that order said it is set aside.
it's modified directing the sudden search. Passed in appeal is set aside.
Is that right?
And that is not right. It should have been revision. Because the context of the order is.
We clarified that the effect of the said order dated 9/7/2021 is setting aside of the order passed in consolidation revision case number 148 of 1993.
Yes, ma'am.
Everything is clarified?
Get to.
Mr. Patnaik,
Yes. And your lordship may can only indicate that the revision will be disposed by the.
No, it has come for correction.
And that also, Bhadrap also we have also mentioned. So if your lordship directs the addition that
It shall not direct now
but that you
because
also get instructions.
this bench is there for is here for this only for correction.
No, that correction also we had sought. That transfer to Bhadrap.
Transfer to Bhadrap.
Because bifurcation, there has been a trifurcation.
Only.
So initially it was Bhubaneswar, then Baleswar.
So which part? Which part of the order?
Your lordship will then seal
That we can do, no. That we can do also only. Well, if your lordship.
Let me clarify.
Yes.
Your lordship may para 5.
Para 5.
Penultimate para, penultimate line.
Yes.
Additional commissioner settlement council is Bhubaneswar. That was once modified to Baleswar. Now then again bifurcated to Bhadrap. Bhadrap matters have been nothing will do.
If see, when the order was passed, Bhubaneswar correct or not?
Yes.
Then we
Yes. That's all. So if your lordship disposes with instead of again directing them to file an affidavit.
No, lordship can pass this order. I assure most I can direct them to transfer the case. It has already been transferred. And I will write them in this order.
It is to go to Bhadrap.
Yes.
Huh?
Yes.
Then we can record your submission.
Yes. That's what I'm saying.
Next, learned AGA has submitted that in view of subsequent bifurcation of the district of Bhubaneswar, comma, the revision case.
Yes.
The revision case number 148 of 1993 is to be transferred to the Court of Additional Commissioner Settlement
And consolidation.
Settlement
and Consolidation. Bhadrap. So he further states that the steps have already been taken. And the records shall be transferred to the Bhadrap court soon. Latest within 2 weeks from today. Talking the night in the background of submission made on behalf of the estate. The appeal stands disposed of.
No, I for modification.
IA for modification, IA so and so stands disposed of.
Urgent copy.
Urgent copy.
Get it.
Item number 2.
No, please, Your Lordship. My learned student appearing for opposite court number 3 and 4. If there was no objection, there was no cause of action subsists in the matter.
When counsel for the petitioner states that cause of action does not survive anymore of this writ application, stands disposed of accordingly. And dispose of review of the said submission.
Item number 3. Item number 3, my last occasion, so I took time for taking instruction. I sought for instruction, but it is not received. So give last chance, then I will. They file application of modification asset dispute of the writ petition.
So what is this matter about?
It is they challenge the order of the central tribunal. So the central administrative tribunal was challenged before this honorable court, my lord, regarding fixation of grade pay, my lord. During the course of hearing, learned counsel said this matter tied up.
It has been disposed of.
Disposed of.
The writ petition has been disposed of.
Yes, my lord.
Then what do you want?
But the learned counsel for the central government submitted that there is a departmental anomaly committee, but there is no such committee. My lord. That is that I want, my lord, for modification.
Where is that? Then you could have filed a review application. Why should we entertain such interlocutory applications in disposal matters?
All right, my lord.
You should file a review.
Yes, sir.
All right. If there is a mistake,
Grant liberty, my lord.
learned counsel for the petitioner after some argument seeks permission to, after some argument, decides not to press IA number 16908. What is that?
Yes, 16908. Yes, my lord.
16908 of 2021 with a liberty to refer a review application seeking review of this court's order dated 16/4/2021. So this application stands disposed of accordingly with the liberty as sought.
Item number 4. All right.
There is delay of 56 days in filing the review application.
How many? How much?
56 days. So we have obtained the certified copy and prepared it. Thereafter we have filed. But judgment was delivered on 27/6/2023. But we have applied the certified copy, but after correction we have got this judgment. So there is a delay because of that. And that can be condoned, my lord. And here the main writ application question raised that the sub-inspector of police appointment, there is age relaxation in civil service. Government come up with the age relaxation for civil service in view of the COVID-19. They have given relaxation for 6 years. But here in this case of sub-inspector recruitment process, they have not adopted the same process, saying that it is guided by the Police Act, Central Act, from where they have formed an order where there is no such, so civil service offer relaxation is not applicable to the recruitment process of the sub-inspector. On that ground.
Then that relaxation should be there in army or not?
No, but
what is the upper age limit for appointment in police?
25 years.
Upper age limit is 25 years.
In general, 32 years. In police, 25 years.
25 years.
Yes, but here the police is in the state list, not in the union list, as per the Constitution of India. And in the upper age limit relaxation clause, there is a notwithstanding clause. So it overrides the
Whether Odisha Police Act has been enacted?
No. They are under Article 309 provision, they are doing this and getting the power from the Police Act. But in the Police Act, there is no provision for recruitment. So it is constitution.
Can we direct them to amend The rules.
Yes, your lordship can.
Very difficult. We cannot.
Your lordship in Bihar and West Bengal, Tripura, all they have adopted to separate their own act.
Why,
But
why,
here in Odisha, that has not been done.
so why review? You could have challenged it in the order.
Yes, because some part of the judgment has not been taken care of.
Sorry, you cannot challenge the order in review.
No, we want review.
Want a review can be done by you. You want a review, but you want us to sit as appellate court.
No, it is because the power of review, question of fact and law.
Sorry,
Well, judgment is there.
you should have challenged the petitioner. One petitioner.
No, there are several petitioners.
Petitioners are seeking a review of an order of this court dated 27/7/2023. Asked in WPC
Hello, pardon, that is 27/6.
2721 of 2023, passed by a coordinate bench of this court. So, while learned counsel appearing on behalf of the applicant petitioner has submitted that several aspects have not been taken into account by the coordinate bench while dismissing the writ application filed by the petitioner for enhancement of maximum age for selection to the post of sub-inspector of police in the wake of COVID situation. So, in our view, the grounds which have been taken for a review of the judgment, this court's judgment, are not valid grounds for the purpose of review. First of the petitioners, in the garb of this court this court cannot act as an appellant court on a review application. First of no error of record apparent on face of it has been pointed out from the court's order, a review of which is being sought. So we do not find it to be a fit case to be entertained in this application. This petition is accordingly dismissed. Yes.
Item number 5.
Yes.
But that decision judgment is there. Some question of law which has not been taken care by the judgment can be reviewed. Because some question of law and some factual aspect which are there.
Assail that in appropriate court.
We have granted liberty to raise this issue in a fresh writ application.
Was any order passed by any court which has granted you liberty to file a case before the Supreme Court? Whether this court should grant such liberty, Mr. Counsel?
Here, in fresh writ application.
Fresh writ application you cannot. Fresh writ application is barred by res judicata.
Because
you could have challenged that.
No, because this question of law has not been taken care of.
Still challenging.
That has not been properly assessed. So we have raised this issue. The BCCI and 2022 judgment Supreme Court. So that can be raised in the review application.
Go before the Supreme Court. Item 5. Yes. Yes. What happened? क्यों आया?
Item number 5.
For restoration.
No, but this is a reasoning of the thing. This a final order has been passed. Final order, he wants it, it's not able to carry it out. He had informed that he'll appear through VC. Okay.
Someone is appearing.
Item number 5.
Whether someone is appearing. Yes.
I don't know, my lord, I'm sorry that there is a discussion in the.
No problem.
Here, your lordship may have a glance to the order dated 6 February 2024. I was directed to file the limitation petition and it is according pursuant to the delay, my lord, it is 30 days delay is there. Lordship may kindly consider.
Oh, whether your application is defective.
No, my lord, application is in order, but it was filed beyond 30 days of limitation.
Final order has been passed, but you know that it is passed on default. So there is modification of that order. CMPL is not.
This application cannot be maintained. You could have filed review application. You could have challenged the orders. But how can you maintain this CMAPL petition?
No, my lord, what I beg to say that pursuant to the concession of the parties, this court arrived at a conclusion and by the order dated 16/12/2022, the matter was disposed of with the direction that they will stay together and resume their happy conjugal life, my lord.
So you could have filed a review application. Or if there is any fresh cause of action, you could have filed appropriate petition, but not this CMAPL.
But I filed it for recalling of that order.
Very difficult. We cannot entertain. As you wish.
My lord, may kindly grant liberty so that I can file.
London counsel appearing on behalf of the petitioner after some argument seeks permission to withdraw this application with a liberty to take appropriate steps before appropriate forum in accordance with law. This application stands disposed of with the liberty as sought.
Item number 6.
My pleasure, lordship. My pleasure, lordships, on the last occasion notice was issued on limitation. Only 25 days delay.
Yeah. So what happened? Why have you filed this application? What for?
No.
Yes, we should
Minus. I am appearing for opposite party number 5, respondent 5. I am appearing for.
Are you opposing?
I am appearing for respondent number 5, opposite party.
Huh? So you are opposing. Are you opposing the prayer for restoration?
No, because the appeal was disposed of not on merits, on default because he had not complied with the order. So that he is applying for recall. So do you actually, are you objecting to that condemnation of delay only how many days? 25 days.
Third learned counsel appearing on behalf of the parties. Delay in filing this application for restoration of what?
Writ appeal.
Of WA number so and so is condoned. IA number for restoration of it. IA number 326. Condonation of delay. Around. IA number 326. IA number 326 allowed. So, with the consent of the parties, in the interest of justice, the order of this court dated 10/8/2023, whereby the writ appeal was dismissed for default is hereby recorded, taking into account the explanation given in the application seeking restoration of the said writ appeal. Stop. Let WA number so and so be restored to its original file. Item number 7. This application is allowed.
I may be part of the submit my lot. And under I number 11/24. Maybe call for both record may be taken over next week.
What happened?
Another I number 11/24 was filed before by lordship. That should come along with this.
It is a disposed of cases, how many IAs?
Only I want for modification because that lady Janaki Vera who was wrongfully confined my lord, that have overage of 70 my lord.
If this is how we start entertaining interlocutory applications,
My lord,
then no case can be said to have been disposed of. All matters are pending because some IA may be filed, may not be filed.
my lord,
So if there is some subsequent development, you take appropriate course of action.
liberty may be granted for subsequent development. I will tell
Counsel
you.
appearing on behalf of the petitioner after some argument decides not to press this application. IA number?
I number
8.
my lord, 11, my lord, 8/20, 11/24, my lord.
8 of 20.
8/24, another is I 11, that is
Not here.
8/24.
The Shopee further submits that he shall not be pressing another interlocutory application registered by number registered by the IA number 11 of 2024 as they relate to developments subsequent to passing of the order. Stop. This application stands disposed of in the light of the submissions so advanced on behalf of the petitioner.
Liberty may be granted to file.
It goes without saying that the petitioner shall have the liberty to approach the appropriate forum in accordance with law or redressal of his grievances.
Item number 8.
Another time for the opposite party and my line senior is held up with Bar Association work, so I'm praying that it may be taken up 1 week after.
What happened?
And for the opposite party, I'm praying that it may be taken up 1 week after.
Has been adjourned.
In such case, I have one prayer. I have filed the application for appropriate direction because they are not complying with directional that is order dated 17/2/2024.
So you have filed review application.
I have filed review application wherein my letter has kind enough do direct by order dated 17/2/2023. They are directing the appeal number 1 with the father that to allow the small children, that is one is 4 years, 3 years, and another is 10 years. To take them each alternate day to the house of the present petitioner.
On what ground you are seeking review?
No, I have filed, but the habeas corpus application was filed by the parent, father of the two child, with the allegation that although both the childs were staying in the house of the present petitioner, who is none other than the grandmother-in-law, maternal grandmother, and they were staying at the root that falls all.
Mr. Counsel, you have, some order has been passed in a writ proceeding. You are seeking review of that order. And grounds for review are very limited.
I do.
So you are invoking which ground to seek review of the order?
My information, at the relevant time, the habeas corpus petition has been filed by the petitioner suppressing all suspect, and the police, although he has not been directed to hand over the child to the father, the police intervened and by applying force, the police will hand over the child to the father. And the mother, both the child, one is 3 years and another 10 years. They are having, the mother has expired some months before, about 6 months before, and from that particular day, they were staying in the house of the parent.
Please be kind to the court. On which ground you are seeking review? Tell us one ground.
The first ground I have taken, that the petitioner is not at all, the habeas corpus is not taken maintained.
Very good, when you could have challenged that. You could have challenged by filing SLP or whatever. You could have gone to Supreme Court.
And the Supreme Court, while admitting the review, had kind enough to direct the concerned both these children to be produced on an alternative date before the house of the parent. Petitioner is just married in never. They are saying around 10 to 15 feet away from both the houses, the distances, and it has not been complied. And I have filed application for the appropriate direction of the Supreme Court, and last time they have taken time to file a counter to that. Now again they are.
That is different. Why are you pressing this review application? Review application cannot be maintained.
But this
other application will.
No, this Supreme Court has taken, this Supreme Court has kind enough to.
And counsel for the petitioner seeks permission to withdraw this application with a liberty to approach appropriate forum in accordance with law in relation to law for securing custody of
children.
Custody of the children. This application stands disposed of with the liberty as sought.
Item number 9.
Item number 9, I'm extremely sorry, my lord. This matter actually was filed when I was in a private chamber, my lord. So it not been, I will seek some time, my lord, because this matter will be done by Mr. Summons, right? He's not here, so I'm adjourning the lordship. Maybe it's about 19th, my lord.
As requested on behalf of the state to list this matter on 1 week.
That also can be done.
Friday, it can be listed on Friday only. Till this Friday.
Yes.
Nice.
Item number 9, I will permit it to withdraw with liberty to approve the appropriate law.
Please admission item number 1.
May I please your lordship?
Yes.
This is an application under section 11 of Arbitration and Conciliation Act, your lordship. On last occasion, I was directed to rectify all the defects. I have rectified all the defects, your lordship.
So what do you want?
Appointment of arbitrator, your notice. Notice to the other side.
Yes, notice. All right.
Obliged.
Item number 2.
Because I appear for the petitioner, this is an application under section 29A of the Arbitration Act, seeking extension of time. On the last occasion, I understand your lordships had mentioned that there is an identical matter on which your lordships have heard the parties, and there was an order which was to be.
Today they are going to make submissions, I believe.
Yes.
So you can stay join, Mr. No. You are Mr.
Naresh Thakkar.
Yes, nice. This is an important matter.
Yes.
In fact, there are two conflicting views of this court. And of course, prima facie, I am satisfied that this court has the jurisdiction, rather only this court has the jurisdiction. But because of conflicting views,
yes, your lordship is right. One decision of your lordship's court, which also in my respectful submission would be per incurium, and therefore your lordships would be well within your rights, my lords, if your lordship was to of the view that, my lords, section 29A under section 29A this court has jurisdiction, then, my lords, a different view can be taken.
I am of the view that instead of holding those orders per incurium, we should have a larger bench decision, so that we may have authoritative pronouncement on this point. This is what I intend to do.
The only issue is that all these
we may request you also to assess this court.
No, that would be most gladly, Milord, I will do that. But Milord, the only thing is that all these matters would then get stuck, Milord, and these are at various stages, and I at least at
no, that will not take much time. That I can assure. That it will not get delayed because of decision by a larger bench.
Very well.
That can be expedited. That should be expedited. This much I can assure.
Very well, Milord. Very well.
Yes. Next.
Item number 3.
Section 11 matter. The arbitration clause is at page 18.
So notice will go. Notice.
Item number 4.
Wait, Lordship. Lordship, this is an application under section 11(6) of the Arbitration and Conciliation Act. File the agreement. Lordship.
Arbitration agreement is there.
Yes, Lordship. Starts from page 9.
So notice will go then first.
Yes, Lordship.
Yes.
Item number 5.
Notice. Was the clause of measure to get to 13 and notice for arbitration at page 2091. Notice for payment. Notice. It's past tense. We are attending but there.
Irrelevant. Item number 6.
Milords, your lordships have heard me in this matter, Milords. Insofar as those judgments of other high courts are concerned, Milords.
Those orders I have seen.
Yes, your lordship.
Where is the order of this court?
Yes, please. I have. These are the. Yes, sir. These are the judgments of this honorable court.
There,
And children are taken care of. हाँ उसमें होगा देखो उसमें है नहीं फाइल के सब नहीं समथिंग इन नो Yes, where are those orders?
Well, I just hand it over. Those two Manupatra judgments. One is Millard's KCS Private Limited, the other is Leela Aditya Dev.
Yes.
Let's may I first take your lordships to the judgment of KCS Private Limited versus Rosie Enterprise. That's the first judgment.
Yes.
This is of 2018 minutes. Reported as 2018 to OLR 781 minutes. Your lordship has that? KCS Private Limited.
Yes, yes, that is there.
Yes. That's why kindly see. Para 1. What? Para 1 has the facts. And straight away take your lordships to the last line. As dispute arose between the parties and could not be resolved amicably, this court, as per order dated 7/4/2016, passed in arbitration petition number such and such, appointed Shri.
Where reading?
Let's para 1 minutes.
The one of KCS.
KCS minutes.
Is Manu Patra.
Yes, minutes.
Begins with in this writ petition.
In this writ petition, minutes, I am reading just the just to get the context, that this is here also, the arbitrator was appointed by this honorable court, not by party so moto. The arbitrator was appointed by this honorable court. The last line, makes it clear. As dispute arose between the parties and could not be resolved amicably, this court, as per order dated 7/4/2016, passed an arbitration petition number such and such, appointed Shri Gayadhar Panda, retired district judge, as the sole arbitrator to decide the dispute. Just to give your lordships the information that there was a 11/6 appointment. Then may kindly have para 6. Similar question arose before a single bench of Kerala High Court in OPC number such and such. Messrs. URC Construction Private Limited, Powerhouse Road, Tamil Nadu, such and such. This is the judgment which was referred to of Kerala High Court, wherein an application was filed under section 29A5 of the Act. The single bench of the Kerala High Court, having taken note of the judgments of the Supreme Court in the case of Pandey and Co-Builders versus State of Bihar, 2007, 1 SCC 467, and in the case of State of West Bengal versus Associated Contractors, right? That under the provisions of the Arbitration and Conciliation Act, the competent court is fixed as the principal civil court exercising original jurisdiction or a high court exercising original civil jurisdiction and no other court. Therefore, the single bench of the Kerala High Court, holding that the Kerala High Court does not have jurisdiction to extend the time under subsection 5 of section 29A of the Act, dismiss the original petition as not maintainable, giving liberty to the petitioner to file appropriate application to the appropriate forum. So, why I cited this parameters? This URC construction is a single bench judgment of Kerala High Court, which has been overturned in lot shipping, which is a judgment that I have given to your lordships already. So, this judgment
was followed by this honorable court in this KCS. So the judgment which forms the basis of the judgment of this honorable court, that judgment itself has been overturned is my humble submission. Next, Lords, if I may take your lordship to para 8. A 3-judge bench of the Supreme Court in the case of State of West Bengal and others Sutra, wherein the question arose that which court has the jurisdiction to entertain and decide the application under section 34 of the Act. Honorable Supreme Court in the case of State of West Bengal and others have held that section 2(1)(e). Yes, plus. So there was the definition of court contextually to section 34.
So, right, click on order.
So let's a reference was made to section 34 and the definition of court that would be assigned to a section 34 proceedings that was referred to, and ultimately it was held in this judgment at para 10 that it is the principal civil court, that is the Honorable District Court, which has the power to hear an application under section 29A5. That is at para 10. Let's this judgment of this honorable court, with great respect, does not take into consideration the beginning phrase of section 2(1).
Yes.
Which starts with unless the context otherwise requires. So this contextual perspective of the definition of court was not taken into consideration, which the other judgments that I have cited before your lordships have for 1 year with effect from the date of judgment. Do agreed, it appears the present petitioner brought writ petition number such and so on the file of this court, and that this writ petition being accepted, this court will direct issuance of notice by its order dated 26/11/2019 as an interim measure, directed stay operation of the judgment dated 3/8/2019 passed in arbitration petition number such and such by the learned district judge, and the matter was taken up for hearing. Well, that's what was argued by the petitioner therein, that is at para 6. If I may take your lordships to Roman 3. This is the arguments of the petitioner. For the appointment of the arbitrator being made at the instance of the High Court in disposal of application under section 11 of the Act, in the matter of extension of memory, jurisdiction lies within the High Court and not the district judge involved herein. It is therefore urged that learned district judge exercising his power under section 29A of the Act becomes illegal. So, the argument that argument was made that district judge doesn't have the powers, this honorable court which has the power. The interim order suffers on account of no jurisdiction of the district judge, and there is no overreaching of power by the district judge. Then, para 8, again, para 7, if I may kindly read. Taking this court with the definition of court, Sri Mahantil Senior Council's
arguments. What is the
this is just this para 7 is the argument by the petitioner, para 8 by the respondent. Taking this court to the definition of court, Sri Mahantil Senior Council submitted that court here means the institution which appointed the arbitrator.
those are arguments.
Yes,
arguments have already been made. What is the
finding view? View minutes is that if your lordship will see, the view is that it is the district judge which has the power.
Where is that?
Yes, if I may take your lordships to let's para 19 if your lordship will see.
And your submission is that that part of
that is to be given to the definition clause with the starting phrase minutes. That is how this judgment was concluded minutes. At para 19 KCS has been referred. This court in a decision dated such and such in the case of KCS Private Limited versus Rosie Enterprise dealing with consideration of an application under section 29A of the Act vis-a-vis definition of court under section 2(1)(e) of the Act, particularly involving an appointment of arbitrator by High Court in exercise of power under section 11 of the Act in deciding the matter in para 819 observed and held as follows. Because I am not reading that because that I've already read out to your lordships.
Then below para 21, for the support of law of land, for the clear application of provision of section 21E, section 29A of the Act, and for the view of this court indicated herein about this court, while finding no strength in the submission of Mr. Monty, senior counsel, also finds there is no infirmity in the include order under Annexure 3. But let's the essentially distinguishing factors. The major distinguishing factor is that this phrase, which imparts a contextual interpretation to the definition of court, that has not been looked into.
There is what for this decision of the Supreme Court was referred to in paragraph 20. Please come to paragraph 20.
Yes,
how does it support the view taken by the learned single judge?
Well, this court takes here into consideration the latest decision of the Apex Court in the case of Union of India versus Chapa Rice Mills, 2021 to SCC 209. Mr. Nathaj is textually right when he emphasizes that section 15.1, it relates to section 15.1, contains a reference to date and not time, but there are two responses to his line of approaching the issue. First, the legislature does not always say everything on the subject. When it enacts a law, every conceivable eventuality which may arise in the future may not be present to the mind of the lawmaker.
This decision may be used by you.
Yes, but
this decision of the Supreme Court supports your view that everything may not be
precisely, but it was referred to by this judgment of Lillard.
How does it support the view taken by taken in that case?
It is only on the question of interpretation, and section 15.1 was referred. So there is no support. This really does not support that it has been referred to in this judgment. That's why it was referred to. That is something academic problem. But in the meanwhile, recently, what has happened in Allahabad High Court, similar situation arose. Conflicting judgments of the Allahabad High Court. In the case of JP Infratech Limited, a similar question was raised. It has been referred to a larger bench. The detailed judgment, if you watch it. (2024) SCC Online Allahabad Total 4.
Yes.
Para 1. These are applications filed under section 29A4 and 5 of the Arbitration Act, praying for extension of the mandate of the arbitral tribunal in order to complete the arbitration proceedings. Let's straight away take your lordships to para 5, which is the question framed by this court, by the Allahabad High Court. During the course of the hearings, this court had formulated the following question of law and asked the parties to make their submissions in accordance with the same. Whether in the case of domestic arbitration, the powers under section 29A4, 5 and 6 of the Act can be exercised by the commercial court or principal civil court, or the powers can be exclusively exercised by a high court, irrespective of the fact that the high court does not have ordinary original civil jurisdiction, and irrespective of the fact that the original appointment was not made by the high court. Then there was a reference to the 176th Law Commission report, which essentially brought in section 29A. Although section 29A came in with effect from 2015, which was just preceded by the 246 Law Commission report, but it was the 176 Law Commission report insofar as 29A is concerned that was taken into view. Para 16, there is a reference to the 176 Law Commission report. There, how this section was originally visualized, that has been shown.
Yes.
In the proposed section 29A by the 176 Law Commission report, the High Court was granted the power to prescribe future procedure by making rules. Relevant para from the said report has been extracted below. This section, section 29A, this section is proposed to be introduced
proposed to be introduced fixed time limits for passing of the award and also for speeding up the arbitral process. No provision was made in the 1996 Act fixing time limits for passing of the award on the ground that extension applications in the court were not being disposed of early enough. And that
decided to refer the matter to a
yes, because identical situations arose there, conflicting judgments. At least 4 judgments were there which are conflicting with each other, and to set the matter at rest, well, it has been referred, which will actually kindly come straight away to the concluding part, para 56, 56 and 57 minutes, which kindly we see.
Yes.
I'm sorry, let's para 55 forever. In light of the same, I am of the view that the controversy involved in the interpretation of the term court in section 29A of the Act is required to be placed before a larger bench in view of the conflicting decisions of this court. Principles, para 56. Principles that emerge based on the following discussion and the consideration of various judgments of the Supreme Court and the High Court have been summarized below. Let's subpara B of para 56. When the phrase, unless the context otherwise requires, precedes a definition clause, it acknowledges the varying circumstances that may arise while interpreting a particular statute, which may necessitate accordingly a different term than the one that has been provided in the definition clause. If a particular term has to be accorded the same meaning throughout the statute, even if it leads to repugnancy and absurdity, the usage of that phrase, unless the context otherwise requires, would become odious. Literal meaning of interpretation is not the only meaning of interpretation, and the rule of purpose in interpretation also needs to be kept in mind, especially in cases where literal interpretation may lead to absurd and unintended consequences, or where such interpretation would go against the very purpose of a particular statute. B. Even though section 29 uses the term court, the same must be read as High Court in the case of a domestic arbitration and as Supreme Court in the case of international arbitration, in cases where the initial appointment of the arbitrator was made by the Supreme Court or the High Court, as the case may be. This is to avoid within 2 different sections of the Act, namely section 11 of the Act and section 29 of the Act, and preserve the principle of judicial hierarchy. Legislature never intend to bestow the power of appointment of the arbitrators to the civil courts or commercial courts, and giving the civil courts or commercial courts the power to substitute an arbitrator under section 29(6), when the original appointment was made by the Supreme Court or the High Court, would amount to defeating the intent of the legislature. The power to substitute an arbitrator under section 29(a)(6) of the Act is similar to the power to appoint an arbitrator under section 11 of the Act. Moreover, if a civil court or commercial court exercise the power under section 29(a), in a case where the High Court or Supreme Court appointed the arbitrator, same would create an anomalous situation wherein a Supreme Court or High Court appointee is subject to the supervision of the lower court. However, in cases where the original appointment was not made by the Supreme Court or the High Court, the court within the meaning of section 21(e) of the Act can exercise powers under section 29(a) of the Act, including the power of substitution.
All right.
So there are 2 questions framed at para 57. These questions, if I may kindly read out, which has been referred to the larger bench. The questions are whether in a case where the appointment of the arbitrator has been made by the Supreme Court or the High Court, it is only the Supreme Court or the High Court respectively that can hear an application under 29(a). Question number 2. Whether in a case
that question should not be answered by the High Court.
Insofar as Supreme Court, that would be better left to the Supreme Court to answer. Whether question number 2, whether in a case where the appointment of the arbitrator was made under the agreement contained between the parties, including the statutory appointments under MSMD Act and NHI Act, and not by the High Court or Supreme Court, the court has defined under 21(e) of the Act can exercise powers under 29(a) of the Act, including the power of substitution under 29(a)(6).
Yes, that's we'll pass on. Yes, Mr. Thakkar, are you there?
Yes, Manoj, I'm around.
You are mute, it seems. You are mute. Yes, please.
Am I audible now, Manoj?
Yes.
So, Manoj, I certainly have no quarrel with what my learned friend has submitted before your lordships. In fact, Manoj, I'm completely in agreement Though, my lords, like I said to your lordships, if your lordships were to consider kindly the decision of this court for a moment, so there is a difference between, my lords, the Allahabad High Court, which sends the matter for the purposes of consideration by a larger bench, as against, my lords, what happened here in this court and the single judge of this court. Just to put things in perspective, insofar as the Allahabad High Court is concerned, my lords, there were two conflicting decisions of the Allahabad High Court. Both the decisions actually consider all the other decisions of various high courts and then come to conflicting decisions. In one, it was held that a 29A application can be considered by the High Court alone. And, my lords, in another, which was Lucknow agencies, the High Court, the same High Court, a coordinate bench comes to a conclusion after considering all of the decisions which are shown to them, that, my lords, it will be the district court and not the High Court. And that is the reason why, my lords, when, my lords, this matter was being reconsidered by the Allahabad High Court, the judge, my lords, chose to, because he had to, my lords, there was no other option. There was no way of distinguishing it, and therefore, my lords, he had no option and he had to refer it to the larger bench. My submission before your lordships is slightly different, which is what I was trying to make in the first instance. And this is, my lords, in addition to what my learned friend has told your lordships. And I completely agree with him, as I said, my lords, on the law, on the point that it ought to be your lordship's court and not the district court at all. However, whether, my lords, this matter should go to a larger bench or not, that today is the question before your lordships. Now, if your lordships are to see the decision of this court in Leeladitya Dev, there, my lords, the only two decisions which have been considered by the High Court, and maybe the reason was that, my lords, the other decisions of various high courts were never placed before his lordship at that point in time, and therefore there was no reason for him to have considered those decisions at all. The only two decisions which have been shown, both those decisions are on different provisions. They are on section 34 and section 42 of the Act respectively, and the question there, my lords, there is no room for doubt that if it is section 34, then the court as defined under section 21E should take precedence vis-a-vis 34, and that would happen for 42 as well. The question whether section 29A, the term court used in section 29A, will also draw color out of the same provision, namely section 21E, was never in question in these two decisions of the Supreme Court. Namely, was the West Bengal decision and the KCS decision, which my learned friend has already referred to. Therefore, it is my submission, my lords, that the decision of your lordship's court is per incurium, and for, my lords, various reasons. One of them is that all those other decisions were never shown to your lordship's court, which means that, my lords, your lordship, while now considering this issue afresh, instead of sending it to the larger bench, this is my, my lords, respectful submission, instead of sending it to the larger bench, if after considering all the decisions of various courts, if your lordships is of the considered opinion that your lordship's court, the earlier decision is per incurium, then that can be avoided in the sense that your lordships need not, my lords, follow that decision, and your lordships can definitely come to a conclusion which will be very different without, my lords, referring the matter to the larger bench. And, my lords, obviously, my lords, one of the issues, like I said, is that at least in the facts of my case, my lords, the matter is closed. The award is to be passed, and I'm today stuck only because, my lords, this application
Extension can be granted with retrospective effect, no?
Yes, my lords, your lordships are right. Your lordships are right. The only thing is that it will, my lords, hold up all these applications. And
it will not take long. This assurance I can give.
No, my lords, I'm obliged to your lordships. I'm certainly obliged to your lordships for that. But, my lords, if this situation can be avoided on the very ground that this is per incurium, and your lordships can certainly take a different view, I don't need to, my lords, even that is something your lordships know very well. If on that basis itself, if your lordships can take a
judicial discipline also requires that generally we should avoid holding judgments of courts, coordinate benches.
What falls from I will only take cue from what falls from your lordships. that generally your lordship should avoid. In this case, where the decision of your lordship's court is per incurium on the face of it, not one decision seen, then your lordships can certainly take a different view. That's my
Decision, there is difference. Those decisions were not binding. Had it been a situation where a binding decision was not taken into account by this court, the matter would have been different.
Your lordships are right. Your lordships are right. But unless those decisions were shown, therefore, what your lordships are saying is that those decisions would certainly have persuasive value for your lordship's court. Persuasive value. Now, even if they were to have persuasive value and they could have persuaded the learned judge to hold a different view, then they are certainly per incurium. That's my submission. He has not even had the benefit.
There is difference. You know it better that there is difference between the judgments of other high courts and judgment of Supreme Court binding, which is binding effect. So ignoring that judgment, if the judgment would have been delivered, the matter would have been different. That could have been easily held per incurium in the light of. Therefore, and that will help for the future also. The controversies will be set at rest as to which court shall have the jurisdiction to extend. At the level of High Court of Orissa.
I'm in your lordship's hands, Malad. This was my submission in addition to what my learned friend has said, because there are a number of decisions which I can also show, but I don't want to multiply that at the moment. I have all the decisions in a compilation. My Malad's attorney is in court. He will hand it over to your lordship.
Please. That's all.
Just in a similar matter, I think that's also listed at item 17.
Yes.
Item 17, your lordships. I'm on the virtual mode today. Lordships. 17, same matter. Your lordships, in fact, in my case, award has been passed. The corrected award is also placed to be passed today. But I would also support your lordship's viewpoint that for the purpose of judicial discipline, this matter may be heard by the larger bench. I would go by that. Of course, I would support Mr. Acharya's all his contentions, because I think last time also when this matter came up, and we did also show our doubts that there are other provisions like 14 where the removal, but I think there is also no bar to looking at the context. The court the word court has to be defined. So yes, maybe in future we would be seeing a situation where even removals would be happening over here because it's been appointed by the High Court here. So I don't think there's a bar to it, and I'll go by the judicial discipline issue. Your lordships maybe refer to the larger bench in that case.
Mr. Thakkar was again. Which is your item, Mr. Thakkar?
Serial number 2, Malad. Serial number 2.
National Aluminium Company Limited versus HCL comment.
Mr. Thakkar's item is 2, and Ms. Rath's item is 17.
17, and your item is
Malad 6. Just two submissions, just to give Malad. Firstly, this while I would like to agree, in fact it will be in the better interest of the case that I would agree with Mr. Thakkar. But insofar as judicial discipline is concerned, that is referred to in para 50, 51, 52 of the recent Allahabad High Court judgment, which says that it was against the judicial discipline of the previous bench to differ from the other judgments of Allahabad High Court. So let's probably in the interest of judicial discipline, and since your lordships are also assuring that it will be
some Kumar's judgment of Supreme Court is there.
What is referred to is State of Punjab versus Devans Modern Breweries Limited 2004-11 SEC. And Central Board of Dawoodi Bora Community versus State of Maharashtra 2005 SEC. Then Pradeep Chandra Parija versus Pramod Chandra Patnaik. Para 50 I'll see to 53.
I'll see heard. So put up for judgment on next Friday.
Great.
Bless.
Grateful, Malad.
That's item number 7 also similar issue is involved. 7 extension of mandate.
7. All right. 747. Yes, same submission. Same line.
Yes.
Great.
Item number 8. Item 8, my lord, I'm praying for an adjournment, my lord. The conducting counsel, Mr. Mante, has some medical issues. That's why, my lord, he is not available.
Your Lordship, I am appealing for the opposite party, Your Lordship. I am appealing for the opposite party. My presence may be noted. Yes, Your Lordship. Opposite party 1 and
The
2.
ground of.
I'm appearing for 3, 4, and 5.
Huh?
I'm appearing for 3, 4, and 5.
Item number 8.
Item 8.
Plan counsel for the petitioner seeks adjournment on the ground that plan counsel for the seeks adjournment to discuss matter on which say when
Anything next week or 1 week after. Next week, no? Next week.
Your Lordship, interim order is there, Your Lordship.
interim order.
Yes, Your Lordship. In our paper, that is IO number 20 of 2023. It may be extended, my lord.
Interim order, if any, shall continue in the meanwhile.
Well, that's item number 10. Let me be obstacles. Going for the petition as 11-6 minus. Classification minus. Never please minus no. Minus no. Item number 11. Is a similar matter. First, then I'll come back to 10 minus. Item minus.
Should they be called? 11 called or
Item 11. Minus. Minus.
Yes.
Minus. When I was talking straight away, company observe that the applicant will 11-6 via 5 minutes, but I'm not sure. I'm not sure 7 minutes. What
is this about?
This is a construction of cyclone shelter minutes by the Odisha State Disaster Management Authority, where pending minutes with the last pending were not cleared as yet, and the final that I after the handing over, and the final bill has not yet been also done by the minutes authorities. And after what has happened, after there was mutual understanding between the parties, between the authority and the petition minutes, mutual arbitration was appointed from the list of arbitration already formed by this annual court minutes. And after the arbitration appointed, and immediately they are cancelled. Then I'm reading on no reason why they are cancelled. And we are not following the procedure minutes. But 11-6 minutes, before
One arbitrator was appointed.
And then, three arbitrators, the choice of within that, the consultant also asked for review, and we had agreed only 3 arbitrators can be appointed. Then after that, they come and this is no procedure not been followed. And nothing come by the procedure was mutually both again. The arbitrator published put at this on me. And here the expressions, the arbitrator has not prepared before them. Here the itself is mentioned, annexion 13 minutes.
No, which procedure was not followed?
God knows what they will, but one application in charge, but where I don't have that clause because I will not go disciplinary to charge. My discipline is not that authority with the financial money.
See,
I will not approve them.
The requirements, condition precedent for invoking 11.6 will have to be satisfied. Yes, my lord. So if any requirement has not been satisfied, the arbitrator could not have been appointed, cannot be appointed.
Because after due diligence and due procedure, management can come to page 120 of annexure 13 matters. Payment will be clear, my lords. Or otherwise, I'll take it before that, my lords. It will be more clear, my lords. Before that.
So after all, you want appointment of an arbitrator.
My lords.
As on date.
Yes, as on date. 11.6 minus possible is referring to the subject I cited above. And to say that on behalf of your client contacted is as per your request.
Reading.
Annexure 13 minus, page 120. 120 minus.
Yes.
One is got in minutes.
Yes.
Appointment of arbitrators on mutual consent to settle the dispute in NCRP cases with reference to the subject cited above. I am to say that on behalf of your clients, contractors, agencies, as per your request, they put an MD, Rosgana by letter number such and such, the following list of arbitrators have been finalized. Based on mutual consent from the list of arbitrators published by the coordinated High Court of Orissa Arbitration Center by notification is to settle the dispute in NCRP cases. And item number 9, let me come to that table minutes, 9 lines. This particular case. NCRP, Engineer Management Corner, and number of arbitrators from the Honorable High Court finalized on mutual consent. That is. So
what do you want? I have not been able to understand.
Again, that we are the appointment of arbitrators.
That is zero solution. And there is an arbitration clause.
Yes.
According to you, you fulfill all the conditions for appointment of an arbitrator. Do you
under fair conditions? I agree to all the conditions. Mutual consent. Yes, Malas.
So they may agree.
Yes, but they agree. And now what they have
has anyone appeared in this case for the other side?
But the state is that the main appeal parties, Orissa State belongs to an inmate and one lawyer, but last time they said to not appealing anymore. But they can.
Let notices go. We will see. Let notice go.
Yes, because the next notice is the timelines and the notice is lawyers have changed after that notice is not gone. Lawyers have changed. The lawyer is changed to those. That's what the last time they submitted that the name may not appear, the name may appear for the organization.
State, it is the contract executed by the
you are representing?
I'm representing the state. In fact, Osman, which is opposite party number 2, they have already filed their counter, but after that there has been a change of counsel, so they haven't appeared.
So we can summon the director of this management authority because it's and stop appearing.
Probably there is a change in the panel of their counsels. So
they could have come. They could have come in person.
There's only one man.
In the council, and if they are not engaged in any other council, then they could have come. So let the managing director come. Place this matter on next Friday. Upon service of notice on, was it party number?
That's option
2. Former opposite party number 2 had entered appearance to a learned counsel. And counter affidavit has been filed. There is no representation. However, on behalf of respondent number 2, place this case on next week. So in the event there is no representation on behalf of respondent number 2 on the next day, the court shall consider passing appropriate orders. You can inform.
10, 11, 12 all are same. 12. That 12. 13 also 13 same, but the council appearing previously known is that, but 12, 13 also 10, 11,
Let it come on.
12 months.
Item number 14.
Malaks, in 14 Malaks, I am appearing today. I admit, Malaks, in the last two occasions, your lordship have allowed me to file counter. But Malaks, the conducting council has given no objection, so I am appearing today. And Malaks, here is an issue where an affidavit is required from the opposite parties. So lordship may give me last opportunity. Within 2 days, I'll file the affidavit. Lordship may take it up next week. Subject to my learned seniors.
By way of fast indulgence, 1 week further time is allowed for the opposite party.
Yes.
To file a counter affidavit. Of this case on 12.
That's opposite party number 1 month.
Opposite party number 1.
Yes.
How many opposite parties are there?
Opposite parties. Both have appeared.
Yes.
Item 15.
Next 2 months.
Item number 15.
This is relating to appointment of an arbitrator. Notices were issued. My friend on the last occasion, he wanted time to come with, he was agreeing for appointment. But he wanted to take instructions from his client.
Just Mr.
Mudli,
Passing it out.
Malak.
As requested on behalf of the
16 also same. 15 and 16 are the same nights.
This matter on the list. This subcolumn 15 and 16.
Item 17.
Malak, my friend, 16 and 16, I have come for the opposite party.
We have agreed, just Dr. Justice D.P. Chaudhary. And the lordship may keep all the objections to be raised before the land arbitrator.
That goes without saying.
Yeah, that goes with.
But that observation only because since the arbitrator is being appointed on consent of the party.
It is unnecessary. The court should not make such observation. See, the scope under section 11(6) of the act is only to appoint an arbitrator. The matter that the moment that is done, the matter is over. All right. Both the cases.
Both the cases.
We are all great. Item 17.
Looks, I appear for the responding to them. The land council appeared, the petition of land council appeared during item number 6 or mentioned the matter alerts. This is a section 29 application filed by the petitioner. The peculiarity here is that the award has already come alerts. The award has come. The award has come on the 14th March. My lords,
the award is nullity.
No, my lords, we have filed an extension application much prior. So it is to be decided, my lords.
It's already taken up that and asked for that. 17 also.
Which matter upon? 17 as in?
Yeah, the land council appeal for Malco mentioned in the during item 6.
Item number 6.
That was taken up.
That is taken.
Item 18.
May I please, my humble prayer, Miller, before our lordship, for appointment of arbitrator under section 11(6) of the Arbitration Constitution Act. Because as per the contract agreement, arbitration clause is found place under special conditions of contract under clause 35.1 at page 48 of my lord's brief. Since the petition opposite party did not make payment as per the contract agreement, the petitioner made a demand and subsequently he denied. Therefore, arbitration dispute arose. For appointment of arbitrator, the petitioner approached the opposite party and the opposite party failed. Therefore, the petitioner has come up before the lordship with a prayer for appointment of arbitrator in view of the arbitration clause. which is found plus at page 48 of my notes book.
It has come for orders.
It's after notice admission. After notice admission, item 80.
Someone is appealing for the other side.
Matter have come up earlier before your lordship, and accordingly, chance was given for their appearance. Previous occasion, your lordship was very much pleased enough to give chance for their appearance, but since they did not appear, accordingly, the matter was adjourned.
What is this Odisha livelihood mission?
It is an organization under the state government. And the present petitioner is the supplier of service agency, being a service agency.
Department of the state government.
That was previously under Panchayat Raj department. Now under it is Mission Shakti department under the government of Orissa.
I am adjourning the matter to 12.
Right.
Please request some state council to be present on the next state. Today also there is no representation for the opposite party or respondent. Opposite party. So place this matter on 12.
Item 19.
Item 19 and 20, my lord, there are two similar matters. This is a matter relating to appointment of arbitrator. Lordship on last occasion issued notice. The arbitration clause is at page 20, my lord.
So you'll have to take first steps for service of notice.
My lord, the opposite party is present. Opposite party proves presence may not be necessary because I have entered into an agreement with the company, my lord. And the address which I have furnished in the cost title is similar to that of reply which they have given, my lord. Now they are refusing to receive.
But you'll have to do it. You'll have to ensure valid service. Let steps be taken for service of notice upon the opposite parties on correct. Possible address. Correct and present address. Requisite storage has to be filed within 1 week.
I need 20 both. Yes, please, 20. No,
18 and 20, my lord. 19, 20.
19 and 20.
I need time to mention Lordships. One advance bail application was Lordships was specifically adjourned to 6th of 2024 Lordships. One advance bail application Lordships have adjourned this matter on 6th of 2024. But it has not till date, it has not been listed. There is no interim order Lordships. So I pray Lordships it may be taken up on the sitting.
If not,
Orders item number 1, ABLAPL 1815 of 2024.
My lord, may I please? This is offense under section 3A of RPUPAC, my lord, and 153 of value property unlawful loss.
Lordship, huge quantity involved. Rupees 4,84,640.
You are paying for whom?
I'm paying for the opposite party. Let the expert antecedent come.
Let criminal antecedent.
Yes, your lordship.
You will see. Yes, what is the allegation? Allegation of a person was apprehended after 2 months of alleged occurrence. And while he is in custody, he uttered the name of the petitioner and others. While he was in custody, he stated the name of the petitioner and others. After 2 months of the alleged occurrence.
What is the allegation?
Stolen or theft coal, my lord. The person who was apprehended, he was apprehended on the spot with stolen coal.
So where is the question of anticipatory bail in such matters?
So far the present petitioner is concerned, my lord.
Your question.
The offences are triable by magistrate, not exceeding 7 years. Offences are triable by magistrate, not exceeding 7 years.
So you can be granted regular bail if you appear. Why anticipatory bail? You are representing whom?
Opposite party in railways.
Railway.
Yes. There are RPUP. RPUP. Yeah, RPUP, railway. Railway property unlawful possession.
Lordship, may I read the provision?
Available in the website, please.
It's not a case for anticipatory bail, Mr. Counsel. Maybe a good case for a regular bail, but not anticipatory bail.
My instruction is there is no CA.
No?
Criminal antecedent.
Maybe.
And my the person while custody violation, he has offered my name, who is before the police. That is not also admissible.
So you may confess.
I'll take instruction, some time may be given to whether criminal antecedent is
No,
there.
but why should you arrest him?
Your
If he
Lordship, yes.
appears before you
Yes.
for the purpose of investigation, interrogation, then why should you arrest?
Yes, Your Lordship. If he
You can appear, we can
Yes, Your Lordship. He may appear in the.
can invoke section 41 capital A of the CRPC.
Yes.
Why arrest?
Yes,
Seek
sir.
instructions on this. Unnecessarily, the people must not be arrested. Already the jails are overcrowded.
And let him appear.
He will not appear. You will have to comply with the requirements of section 41A.
Yes, sir.
May issue notice. He may appear before you. You may interrogate him. Like that. And what is the punishment?
I guess.
3 years or more, but not exceeding 7 years.
So, 5 years for first offense. 5 years for first offense and 7 years for second.
Counsel appearing on behalf of the opposite party seeks adjournment in order to seek instructions as to whether instead of arresting the petitioner, the investigating agency shall invoke section 41 capital A of the CRPC for the petitioner's attendance for the purpose of interrogation/investigation. Item number 2, list this matter on 1 week, how much? 2 weeks?
2 weeks.
Item 2.
Maybe just. Similar to one of the quarters has been similar to one of the quarters has been granted there by the something. ABL opinion number 2. Anticipated.
379, 411, but.
And other person has been granted bill. Where is that order?
That is ABL opinion number 2.
Where is that order, sir? You want us to see through on the net?
It was like a cause list. It was
in the cause list is there. Yeah.
Cause list. Co-accused bills.
Copy is annexed.
2033.
Allowed the Abdullah.
There are almost 8 8 FIR named accused persons. So who has gone? To know that.
Abdullah. But in that case, there are 8.
8 FIR named accused. 8 accused in the FIR. So who has gone in bail, my lord, that is not clear. He's saying.
No, Abdullah Hussain.
Abdullah, yes.
Abdullah has been granted bail. That order is there.
No, no, Lordship, you can.
Counsel for the petitioner has drawn this court's attention to an order dated 11/3/2024, passed in ABLPL number 2033 of 2024, whereby co-accused Abdullah Hussain so and so has been granted privilege of anticipatory bail. Stop. Next, upon perusal of the materials on record, I am satisfied that the petitioner's case cannot be distinguished from the case of so and so who has been granted anticipatory bail by the aforesaid order. First of all, accordingly, so as to maintain parity, this application is allowed. Order first. Yes.
Item number 3. Made reversed. It is a custody bail, lordships. The petition is custody since 12/1/2024. For the alleged offence under section 457, 395, 458, 398, and 400 of IPC and read with section 25 and 27 of Arms Act, lordships. The allegation, lordships, 7 to 8 persons entered in a illegal premises and manhandled the security guard and stolen some copperware and ATM card, gold, mobile phone from the security person, lordships. New lordships, basically with the co-accused statement, this petition has been entered in this case, lordships. One co-accused named Bimal Mahalik, and in fact, he has been released on bail by the court below, lordships. And your lordships, the TI file, this petition has not been identified.
So you are in custody since when?
Custody since, lordships,
12/1/2024. 12 January 2024.
But the allegation is very serious.
Lordships, basically with the co-accused statement, I have been interviewed. Basically with the co-accused statement, I have been involved with this case, lordships. And whose statement I have been involved, lordships, he has been released on bail by the court below, lordships. Oh, that is one Bimal Mahalik, lordships. That is one Bimal Mahalik.
Bimal?
Bimal Mahalik.
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 It is his confessional statement on the basis of which
I have been entitled, lordships.
FIR was registered against how many persons?
Unknown persons, lordships. FIR against unknown persons, lordships. Unknown one. That has been written.
Unknown?
Unknown one. It has been accused column. Unknown one. It has been written.
Means?
What a 1% that reflects worship, but in fact 7 to 8%.
The body of the FIR says that 7 to 8 unknown persons.
7 to 8 unknown persons.
The FIR was registered against unknown. According to the prosecution's case, in the night of 30/31/12/2023, at about 12:30 AM, nearly 7 to 8 persons entered inside the Chakka structure means
That is a college structure. There is one political structure, construction structure versus
inside structure of Chakka College. Structure of Chakka College.
College structure versus college Chak structure.
Entered inside the premises of college armed variously. They overpowered the security guard on the point of pistol, manhandled him and others. They confined them inside a room and terrorized the deputy manager. They are said to have taken away their purses, ATM cards, gold locket, mobile phone, etc. Learned counsel appearing on behalf of the petitioner has argued that he is in custody since 12/1/2024 and his name has surfaced during the course of investigation based on confessional statement said to have been made by one of the accused before the police during his custody. First off, he submits that there is no recovery from the petitioner's possession and confessional statement of co-accused before the police has no evidentiary value. So, next. Considering the submission that the confessional statement of one of the accused is the only basis for the petitioner's implication and the fact that the said accused person, Bimal Mohali, has been granted bail by the court below, this application is allowed.
Maybe pardon your lordship. In item 1, different order has been passed in a similar co-accused of arising out of the same case. Your lordship was not inclined to grant bail. Rather, your lordship has directed to surrender before the learned court below. That he has suppressed that. That is AVLAPL number 1664 of 2024.
So, make your submission on the next day.
Yes, your lordship.
Make your submissions on the next day. His anticipatory bail application was rejected earlier.
Yes, your lordship. Another co-accused.
All right. So, it should invoke 41A instead of in other cases also where anticipatory bail is rejected.
Yes, your lordship.
It is not that you are required to arrest them. Just that is the law laid down by Supreme Court.
I only request before lordship that different order has been passed in that bail which has been disposed of by your lordship.
You will see.
Yeah.
I'll see that.
Okay.
Show me.
Item number 4.
Met lordship. Offense under section 20B2C. Your lordship granted bail to one of the co-accused who is not one of the similar footing to the present petitioner The prosecution case is the contraband ganja of different quantities in different bags were kept in a public place, that is a bus rested. Some persons were there, and the informant concerned, he went to the spot, seized all those bags and arrested 5 persons, and all total 34 kg of contraband ganja were seized. And the informant in the FIR itself stated that so that the bag contains 22 kg is attributed to the present petitioner. But it is the case of the prosecution that no one was holding any bag. It was kept in a public place. 5 persons were there nearby the bags. Under the page 10 number kind of glance, the FIR. Present petitioner having no criminal antecedent, page 10 under the 17th line from the top. At 9:45 a.m., I, along with witnesses and staff, reached at near Shankara Chowk and found what it meant. 17th line from the top starts with at 9:45 a.m.
You are reading which page?
Page 10, Melo.
Yes.
At 9:45 a.m., I, along with witnesses and my staff, reached at near Shankara Chowk and found 4 female reading. My lord?
Where are reading?
Page 10 was from the top, was 17th line from the top. Starts with
17th line.
Yes, my lord. 1 second.
How can I?
It starts at 9:45 a.m. My lord, the starts with. So I'm reading it from the beginning.
Yes.
But at 9:45 a.m., I, along with witnesses and my staff, reached at near Shankara Chowk and found 4 female persons and 1 male person are sitting on the rest shed to load the ganja and to go by a bus at a early spot with their vanity of the bags which were kept nearby them. No one was holding any bag on the next page. It was stated that so from the one bag contains 22 kg and other 4 bags contains 3 kg each.
Seek instructions.
We've not received the case diary or the antecedents. In this case, what we call it for the criminal antecedents.
Yes, the local.
Also, we can write in view of the submission advanced on behalf of the petitioner that there was no recovery from his possession.
Yes.
No recovery of any contraband articles from his possession.
Your lordship granted bail to one of the co-accused. Like whose possession that copy is with me.
Less quantity was recovered.
3 kg only. That is attributed to him. Yes.
Let criminal antecedent of the petitioner be also ascertained by learned AGA. Yes, public. 2 weeks. 2 weeks. 2 weeks. 2 weeks. 2 weeks.
Yes.
For orders item number 5.
Order number
1. In the top. On the top, the nomenclature.
BLPL.
It should be BLF.
let the registry carry out correction in the registration. Number of the case. There appears to be a manifest typographical error in the order dated 27/3/2024, wherein BALPL number 2572 of 2024 has been typed in place of BLAPL. Stop. The correction will be correct. Will they make corrections? Let the registry take necessary steps for typing fresh orders or fresh order with correct nomenclature.
So item take similar order.
Item number 11.
This matter may only say one thing. Lord, I am just to get the instruction. I have sent a registered letter to Koraput distant place regarding the second item. I am there. May I humbly pray for 2 weeks time to 2 weeks after in that.
It is 26 years. 7 years.
What is their position, whether they are alive or not, anything. So I have just to do justice for the client I have written. Otherwise, I would be feel myself guilty. That's why Lordship may kindly grant 2 weeks after.
So what is your submission item in item number 1?
Item number both, same.
What is the offense?
Docket
390?
595.
And what is the sentence?
After 5 years, more than 2.5 years, they are already against.
That instruction is that.
And what is the maximum minimum punishment?
No minimum punishment, up to 10.
Minimum is 5.
Minimum. Over there.
Only 5 years. Yes, sir. Arrived for 5 years. That is
No. My lord is asking whether minimum up to her stage. Up to 10. Up to 10.
live years. 295.
If you confine your submission, I can reduce it to the period undergone.
That by next date, I would only. By next date,
It looks bad. 97 matters are pending.
I have already given the rest letter. Otherwise, I am not have there before your lord.
Right. Next week then.
Next week, I don't get. Week after, I get. I am not. I am 2 weeks. I am not now praying. Week after, let it come. Week after, just. I was praying 2 weeks after initially. Week after, some other. I have just intimated the local lawyer. I have said it
will come on 12th. Will there be?
Let it come. Yes.
As requested on behalf of the petitioner, is this matter on 12th?
Item number 12.
I am very worried about this pendency of criminal division. Very,
I also.
Very painful. 10,000 criminal divisions are pending. We will have to do something. Yes.
Item number 12.
The order sheet indicates that there has been no representation on behalf of the petitioner on most of the times. This application is accordingly dismissed for default.
Item number 13.
No representation. Dismissed. All.